And so this response just illustrates the agency's failures to assess his disabilities as a whole. And I see that I'm out of time. Thank you.
Great. Thank you both.
This response just illustrates that have facilitated communication where a hearing sign language interpreter could not have because of those other limitations. And so this response just illustrates the agency's failures to assess his disabilities as a whole. And I see that I'm out of time. Thank you.
Great. Thank you both for the helpful argument. The case is submitted. The next case we have for argument is Brown versus Salcido.
Appeal that decision. They were not going to go to trial. They were going to settle all their claims. They have a class action settlement. They filed a motion for final approval of that class action settlement. Before that was even heard, we filed a motion to intervene so that we'd be positioned, once final decision was reached, to be able to appeal that final remaining issue. And so, no, we wouldn't immediately appeal. We still have to await a final decision. And in fact, there may not be a final decision. Obviously, the settlement has been put on hold. The court has said there are fundamental issues of fairness that have been raised. We don't know what will happen. And so it may end up being that the case gets resolved in a different way, and we don't have to appeal that. It may be that the representatives will appeal it themselves, depending on how they ultimately resolve this case. But we just want that right to be preserved and not lost, as it would have been if the court had granted final approval on the proposed settlement.
But there could be no class settlement. Then I guess what you would intervene, you would kind of unravel the settlement, and then try your case individually, get a final judgment, then appeal the class cert denial?
We're not seeking to unravel the settlement, and that's not part of our, we anticipate that there was going to be a final approval and a dismissal of all claims. We wanted to be able to appeal that one issue, which was the denial of the certification of a damages class. And so we think they reached a good settlement with respect to injunctive relief. It definitely benefited the class. We have no issues with that. And it's right now it's on hold. I would imagine, and I don't have any evidence to this, but I would imagine that once the parties found out, they were expressly relinquishing the right to appeal the certification of the damages class. That's an important settlement provision. I would imagine that may have thrown a wrench into the ultimate agreement to settle. They had hoped no one would take that up. They wanted it to be gone. It was part of the settlement agreement. And we're simply standing up for the class, saying there's going to be tens of millions, according to their own language, perhaps tens of millions of people who will never effectively have an opportunity to pursue these claims, because without a class action vehicle, it's just not practical and it won't happen.
Well, isn't the proper vehicle here just to be your clients to be objectors? Because it seems like you're attacking the fairness of the settlement. Just wait until it goes up to the district court has to approve. But you can go in there and say, hey, these non-named class members are getting a raw deal. We don't think it's fair. Go back to the table. Isn't that? It seems like that's the more proper vehicle rather than this kind of intervention.
Well, but we actually don't object to the settlement.
Well, you do. Right? The damages that the people aren't people who aren't the class reps aren't getting any damages.
In the motion for approval and in the settlement agreement itself, they expressly tell the court that the other class members, the unnamed, the putative class members in the damages class, are free to go and appeal this themselves. This is what they're telling the court. That's all we want to be able to do. Just follow the dictates of the settlement agreement. They're settling everything. They're settling their individual damages. They're settling the injunctive relief. They're settling the attorney's fees. And they're saying, look, if other class members want to appeal this issue, this is what they told the court in their filings. If they want to appeal this issue, they are free to do so. They are not giving up that right. So we're picking up the ball saying we would like to appeal that issue. It's valuable, it's important to us and to unnamed class members who do not have their damages being litigated. So go ahead with your settlement, that's fine. Let us appeal on this issue.
Well, is there a settlement? I mean, I'm trying to unfold what happens. If you're allowed to intervene, you basically, as Judge Lee points out, what seems to be at issue here is the differential treatment between the class representatives and the absent class members with regard to ability to pursue claims. You're free to pursue claims if we've got a statute of limitations problem. And so can the settlement actually be concluded if in fact you're there insisting upon the right to appeal the
There's-
damages element?
That's a practical, like a negotiation question between.
Well,
the
yeah,
parties.
that's what I mean. I mean, you can, it's all well and good for you to say the settlement can go forward, but I don't understand how that actually works.
Yeah, so, Your Honor, this happens commonly, that the named plaintiffs settle their case, their issues, and they're done, and someone else intervenes to pick up the ball on other things. And so it's not uncommon. We have plenty of cases where this happens. So there's no legal impediment to it. It can happen. And so that's.
Is there a settlement? I mean, do they actually conclude the settlement that they've negotiated if in fact the term of the settlement which says there will not be an appeal of the class certification issue with regard to damages, that's no longer the case because you're appealing it?
I can't answer that, but what they told the court was that the unnamed class members, other people, were free to pick up this issue and move with it. So according to their representations to the court, they were okay with settling along these lines and allowing other people to appeal this issue. That's what they told the court. Whether that's true, whether seriously there's a practical issue or not, but in their representations, they said, we are not binding the hands of the unnamed class members when it comes to individual damages, and they are not waiving any rights with respect to damages. And so now, is there a practical effect? I'm sure there is. I don't know what it is. I'm not privy to those conversations. I'm not on that side of the fence. And so I don't know. And I don't think there's anything in the record that will tell us one way or the other. But our position is we actually liked the settlement. We liked every part of it except for this one thing. And we felt our preference would be for the settlement agreement to go forward as planned. And they didn't move to stop the settlement. They didn't ask the court to freeze because of this proceeding. The court took it upon itself, the trial court, to not move forward to the final approval because of the issues that are being raised here. And so they haven't made any formal statements to the court that they don't want to move forward with their settlement. No one's told us that the settlement's off now because someone's seeking to appeal the denial of the class damages, someone else other than the party to the settlement agreement. And so again, this is a lot of conjecture, but I do think it's important. I think when we go back to the actual motion, which is supposed to be construed liberally, it's supposed to be very permissive to allow people that may have their rights impaired as a practical matter to be intervened. This is seen all the time. We were only asking for that opportunity to discuss that and to be able to be in a position to appeal it if it was truly going to be abandoned. And I just think that the court's reason for denying it, that she was wrong. I think that she misconstrued the law, and I think it should be reversed based on well-established case law.
Can you briefly address timeliness? Why did you wait 3 months after the settlement became public to file your motion to intervene?
There was two things going on. First of all, as we informed the court, there was a reference in the motion for approval of the settlement agreement to a tolling agreement. It was no details were given at all. I kind of funnily pointed out that it was on page 48, paragraph 175 of Exhibit 11, but it was just this one little passage in Mark Mao's declaration where we stumbled upon it because there was no formal notice given to the class. You have to be watching the docket to even know this was going on. So no notice to the class. We saw that there was a tolling agreement. It did not explain what the scope or the terms of those tolling agreement was. We didn't know how much it would affect our clients or not. We sought to get copies of the tolling agreement. We put into the record some of the email exchanges. We were told we could go get it from Google. We were told that it was confidential. It wasn't until we filed our motion to intervene that we finally got a copy of it. And there was also phone calls. So there was some effort to try to find out. It's a big step. It's a big thing to this amazing firm who's done great work and put together a fantastic course of litigation over 4 years and exposed a wrongdoing in our mind and are protecting people to step in and intervene. It was something we didn't do lightly. We didn't want to do lightly. We wanted to see if that tolling agreement would have allowed us to protect our own clients' interests and be okay. And we were just forced to do it.
Is it common for tolling agreements to cover, unnamed at the absent class members typically?
It could, especially if they were going to go out on an advertising campaign and try to pick up other clients for the damages portion of it, because they were going to pursue those damages portions in a different venue. And so we didn't know what it could include. And so we just didn't know, and we wanted to be able to see what it is and have all the facts. So it was 3 months, but it was, again, the Supreme Court has said that the timing for this is after final judgment and before the deadline to appeal. So we felt like we were premature, and we actually felt like we were moving prematurely, but we needed to get a copy of the tolling agreement, and we needed access to documents. And so I don't think there was any undue delay. And remember, the issue of delay, this court has said, the issue of delay has to be couched in the context of prejudice. That's the only reason. In the Calvert's decision, it says it's not supposed to be punitive. Is the delay, does it cause legal prejudice? No prejudice. In that 3 months, nothing of significance took place. And it was a month before there was even going to be a hearing. The hearing was set for August of 2024 on that final approval. So 0 prejudice, very small delay. We had reasons for the delay, and I think we were premature even then. And I'm not sure if this is
That's total, so you're well into your 5
Okay.
minutes. We've taken you there.
Okay, thank you. I'll reserve if that's okay, Your Honor.
Great, thank you.
Thank you.
Good morning. May it please the court. Stephen Broom from Quinn Emanuel, and I represent Google. Mr. Handy just told the court that we're not seeking to unravel the settlement. But that is what they argued in the proceedings below. And there has been somewhat of what I'd call a moving target problem in the sense of what exactly the purpose is that the purpose for which they're intervening has been far from clear. In the proceeding below, what they said to the court is that they wanted to get a copy of the tolling agreement so that they could consider their position on the settlement and to potentially prevent a so-called sweetheart deal where the named plaintiffs would get to resolve their claims in arbitration. But then they got the tolling agreement and they did not object to the settlement. And I agree with you, Judge Lee, that the proper way to challenge the settlement, if that is indeed what they were trying to do, would be by filing an objection, and they have not done that. And Mr. Handy has said that he does not object to the settlement. But at the hearing below, they shifted their position. They made clear that they were, I'm sorry, at the hearing below, Judge Gonzalez-Rogers specifically asked counsel for interveners, are you planning on taking an appeal yourselves? And he said, no, because there would be no jurisdiction under the Supreme Court's decisions in Microsoft v. Baker and this court's unpublished decisions in Bobbitt and Martinez, which came out directly after Microsoft v. Baker. Now on appeal, their position has shifted. In fact, I think it's shifted enough that we would argue that what they are seeking now has not actually been, was not actually raised below and would be relief that they're seeking for the first time on appeal. Now they say in their opening brief that they want to take the appeal themselves. And then on their reply brief, they say, well, maybe we won't actually need an appeal. And this is at page 3 of their reply brief. They say, what we really want is a seat at the table to discuss the interests of the absent class members in the damages claims and the certification issue. Well, again, there is a process for getting that seat at the table when you want to have input on a settlement agreement. And that is by filing an objection, which again, they haven't done. So you can't fault the district court for denying their motion to intervene when what they argued below was we want to challenge this supposed sweetheart deal between the plaintiffs and Google. And she rejected that. They had not moved by the right process. They had not done it timely. They knew in December that we were settling this case. And since it was only a B2 class certified, they knew it was only going to be a B2 settlement. Now their position.
Sorry,
Yes,
do they
Judge
still
Lee.
have time to file an objection, or is that time passed, or what's, I don't know.
I would say that time has passed, yeah, because we've already had the final approval hearing. Now if what they want to do, as they say in their opening appeal brief, they want to take an immediate appeal of the class certification decision, well, that's impossible, right? The district court has not resolved a single claim on the merits. We lost at the motion to dismiss stage. We moved to dismiss all claims. We lost. None of those were resolved in the merits. Same at summary judgment. We lost again. None of those claims were resolved in the merits. And then we settled before trial. So there has been no final decision in this case. And if, under Microsoft v. Baker, if the plaintiffs had settled with us and had not, let's assume we had not included this provision about waiving their right to appeal, which I'll explain in a moment is not nearly as nefarious as it sounds. If we had excluded that provision and just had a settlement and a voluntary dismissal with prejudice, There would be no final decision. The plaintiffs certainly could not take an appeal of that decision. This court would have no jurisdiction. That's clear from Microsoft v. Baker. And nor should the interveners be able to come along and do what the plaintiffs could not do, right? If the plaintiffs cannot appeal the district court's class certification decision, the interveners should not be able to do that either. Otherwise, they would have some privileged status as interveners that the plaintiffs themselves don't have. Where we are now is that unless the settlement is rejected, and let's say the interveners are allowed to intervene, they still need to try their claims. And I think, Judge Lee, you're alluding to this in your questions. They still need to try their claims through to a final judgment, right? And that necessarily unwinds the settlement. I mean, the key aspect from Google's perspective is finality. We thought we were settling the case. If they're going to intervene and come and take an appeal of the B3, we presumably would be entitled to then also appeal the grant of the B2, which again could unwind the settlement if we were to prevail. And then, if you think about this from a practical perspective, what happens if Mr. Handy succeeds in getting this court to reverse the district court's B3 denial, right? We would then have to go, we don't have any more plaintiffs, right? Then they would need to intervene and presumably step into the shoes of the named plaintiffs. We would need discovery. We would need expert discovery on those named plaintiffs. We would have to have another round of summary judgment briefing. And we'd probably have to take the case to trial. So from a practical perspective, what they are asking for is not realistic.
So you've really answered the question posed earlier, which is that if the appeal by, I keep thinking of them as objectors, because usually it comes up in that guise,
Right.
the proposed interveners, that ends the settlement. That could be redone later, but the existing settlement on the table blows up.
That's exactly right, Judge Clifton. Yeah. And I do want to make sure I address a couple of the key cases.
Counsel, the one thing I would like you to address, I know you've only got a minute or so, but I'd like to get an answer, is all of this is very, very interesting, but this is not the basis for the district court's decision. The basis for the district court's decision was that their motion wasn't timely. Can you tell me why it's not timely?
Sure, it was twofold. It was, one, they hadn't established a protectable interest, and two, it was untimely. Yeah, I think the timeliness question turns on what is the purpose for which they're seeking intervention. And this goes to the point I raised earlier. If they were seeking intervention for the purpose they claim now, solely to take the appeal, then I think they are right that, under United Airlines versus McDonald, the time for doing that would be within the 30-day window after the settlement. But again, that's not allowed anymore because since United Airlines versus McDonald, the Supreme Court issued its Microsoft decision, and then this court's Bobbitt and Martinez decisions make clear that appeal can't be taken. But if the purpose for which they were seeking intervention was to do what they told the district court they were trying to do, and I see I'm out of time, if I may just finish my answer.
Yeah, please.
Then, that was to challenge the settlement. They said they wanted to challenge this supposed sweetheart deal and the release of the appellate rights, and that is an objection to a settlement. And the time for doing that was as soon as they learned that we were settling, because they knew at that point, and that was December 23rd of 2023, we announced that we had settled. They knew it was a B2 only class. And I would submit that there is a case that addresses this timeliness issue very directly that we've cited in our papers. And it's this court's 1986 decision in Orange County v. Air California. And the court does impose a fairly demanding standard on interveners in that situation. It says as soon as you have any notion that your rights might be affected by a forthcoming settlement, you need to intervene right away and get a seat at the negotiating table so that you can protect whatever rights you want to protect. If you don't do that and you wait, and then the settlement comes out and you say, oh, well, I don't like the settlement, then that's too late. And in this case, we announced the settlement December 23rd, 2023. They did not raise any concerns until 5 months later. Meanwhile, they spent that time filing their individual actions.
Great, thank you.
Thank you, Your Honor.
Morning, Your Honor. David Boys, may it please the court. I'd like the court to consider 4 points. First, with respect to Bobbitt and Martinez, those are cases that I respectfully suggest are on all fours with what the court is presented with today. You had a situation in which you had a class action, class cert was denied, the case was settled, people came along, tried to intervene for the sole purpose of appealing the denial of class certification, which is what the movements here say that they intend to do. And the court held twice, first in Bobbitt, then in Martinez, that there was no jurisdiction to do that following the Microsoft case. I don't think that this case is distinguishable from those two decisions. Second, what is happening here is that they're trying to go around the Microsoft case. The Microsoft case holds that if somebody settles and dismisses their case, that's not a final judgment for appeal. What they're trying to do is say, well, if somebody else comes in and tries to intervene, then they can appeal that decision. That would entirely unravel what the Supreme Court did in Microsoft, and that was...
Well, not if we take Microsoft to stand for appeal at that time, but if they intervene and further proceedings in the district court lead to something that's an appealable final judgment, couldn't they appeal them?
I think if that had been what they had said to the district court, that would be an entirely different situation. The third point I'd like the court to consider is that what the district court was presented with was 185 people trying to intervene who had already filed cases, which cases were pending at the time, covering the same subject matter. And so the court held not only timelessness, they held it was not impairment, because they not only could file cases, they had filed cases. This was not a situation in which people were coming in and needed to do something to protect their right to sue. They were already suing. And what the court was doing was denying intervention into the class action for people who already had cases pending on the same subject matter. The court was confronted not with a situation in which they said, we want to intervene in order to litigate. The court was, and this is...
Well, but what were their prospects in those separate lawsuits? I mean, didn't they face a limitations problem?
They may face a limitations problem. They've argued in those cases they do not face a limitations problem. But whether they face a limitations problem or not is not something that depends on whether there's a class action or not. I think the law is pretty clear from the Supreme Court and in this circuit that once a district court denies class certification, tolling resumes. Tolling ends. And so if they've lost their case, if they've lost their cause of action because of the statute of limitations, they've lost it whether they're in a class action or whether they're filing individual actions.
Well, their focus is on the tolling and the fact that the tolling agreement did not, which would have extended the tolling period, did not apply to their clients. Now, it can fairly be argued that that's the moment at which they needed to speak up and take action, and they didn't, and that gets to the timeliness problem that underlies the district court order. But the reality is that the tolling problem is there, and there's some logic in the sense that the only serious relief available to them would be if somehow they could get the tolling period extended to cover them as well.
I think that's fair, Your Honor. But I think that is the situation in every case, where people don't bring actions. This was a very public action. Our settlement in December of was a very public action.
At what point did it become more common knowledge that the tolling agreement was limited to the class representatives, and that the ability thereafter to pursue a separate damage claim was going to be limited to them?
The tolling agreement is not limited to the class representatives. The tolling agreement is entirely separate from the class representatives. The class representatives preserve their action by bringing their case, and that case is going to be resolved in arbitration. The tolling agreement relates to other people, other putative class members who are going to have brought suit. That was not something that related to the class representatives. The class representatives.
So the only distinction for the class representatives has to do with the pursuit of the claims through arbitration?
Yes, the class representatives agreed as part of the settlement to pursue arbitration as opposed to continue to, and that was something that was, publicly known long before they intervened.
Can you address that one again, the tolling agreement? Your friend on the other side said, yeah, I didn't know what the tolling agreement said, so I waited 3 months. I mean, can you address that? I assume you think that was unreasonable, or can you address that point?
Well, I think that, I think it's fair that he did not know exactly what the tolling agreement said. I think that was not a reason that he could delay intervention if he wanted to intervene. What he's saying is he wanted, and this goes back to the fact that he said something different to the district court than what he's saying to this court. Before the district court, he said, I want to intervene because I want to understand the discovery. I want to get access to discovery. I want to intervene because I don't want the class representatives to give up their claims. Now what he's saying is, I want to intervene so that I can have one of my people come in and pick up the cudgel. And what the court said in Microsoft is that you don't have jurisdiction unless you have something that is, the class action's got to be tethered to a claim. Justice Thomas's concurrence, which talks about the Article 3 problem, the majority didn't reach Article 3. They decided it on statutory interpretation of 1291 and Rule 23F. But in the concurrence opinion, they do deal with the Article 3 problem. And what they're asking here, and what they were asking the district court in particular, was allow us simply to come in untethered to any claim. They weren't asking the district court to do what they're now asking, what they're now saying they want to do. So what you're presented with is the district court looking at what the district court was being told, acted entirely appropriately. I think even they sort of, by changing their argument to this court, recognizes that what they were arguing to the district court didn't justify intervention. But that's the basis that the district court made a decision on. I respectfully suggest they can't now come to this court, argue other reasons for intervention, other bases for intervention, and then ask this court to reverse what the district court did based on a very justifiable interpretation of what they were presenting then. I think my time has expired.
Great, thank you.
Thank you, Your Honor.
Thank you, Your Honor. Just a couple points. First of all, it is true that that these clients were suing, but there is a statute of limitations issue. The court actually ruled that we were time barred. That's where we stand today. Did give us permission to amend the complaint to try to do some delayed discovery rule allegations that might save that. But as it stands right now, we're time barred on those other cases. So this is very important to our clients. Second of all, in our motion to intervene, we did argue alternative reasons, and we even used that phrase in the headings. Alternatively, we should be allowed to intervene so we could get access to discovery. Alternatively, we put these other things in there. But that doesn't take away the fact that we clearly, and everyone understood, wanted to intervene for that issue of the denial of the class certification. That's why Judge Rogers said, you should have then intervened when I denied it 2 years ago. I mean, there's no question this is not a changing position. That's always been our position. Another thing is, he mentioned, Google's counsel rep mentioned that, oh, we actually informed everyone of the settlement back in December. No, one paragraph, a preliminary notice that they had reached a settlement with not a single term being disclosed. It wasn't until April 1st that they actually filed the actual copy of the settlement agreement, and that's when everyone found out, oh, okay, they're getting rid of all this, they're waiving the right to do this, they're no longer going to appeal the denial of the class certification. So that's just a faulty timeline. They gave a preliminary notice of one paragraph saying, hey, everyone, we should put off the trial dates because we've settled. And we will file something. And then 5 months later, they did file something in a motion. And that started all this activity. It is true that the tolling agreement is not for the class representatives. The tolling agreement just protects other Boies-Schiller's clients that they've signed up that they're going to pursue damages, just for their own clients, none of the rest of the class members. And so that is true that the tolling agreement goes beyond class representatives. It's just their own book of clients that they have. And so it leaves the other ones without any protection and no tolling agreement. I think that's one of the reasons why they said it wasn't relevant.
We've all seen this a lot in terms of objections to the class action terms.
Yeah.
And I keep trying to categorize this and mistakenly use the term objectors before. That's how we most often see this. Why don't we see this complaint? Why didn't we see this complaint in that form in this case? Why wasn't there an objection based on the differential treatment?
Yeah, that's a good point, and it goes back to something else that was raised. We talked about it being untethered, and we'd have to try claims in order to have the right to appeal. Well, that's not true. The same 23B2 class, the injunctive relief class, is identical to the 23B3 class. So all the clients, all the interveners, and the people that would want to appeal, other than the named representatives, they already had all their issues determined. They on the injunctive relief, they're getting full settlement. We like the settlement agreement. We like the remedial things that are going on in the settlement agreement. And it pays the attorneys who did all their work, and we don't have a problem with that. It's the only thing that's outstanding is that the class representatives, the named plaintiffs are settling their damages claims, and only their damages claims, leaving the rest to deal with their damages claims. Well, we don't have to try those in order to see if we can do it in a class vehicle. That's the whole point. We'd like to appeal the denial of class treatment.
See, but what that serves to me to be a objection to the settlement, because the settlement doesn't survive if you prevail, and I realize I'm taking over time, but settlement just doesn't survive. I never realistically thought it could. It was pretty clear from your colleagues that no, this settlement is gone. It might be redone somehow, but the motivation on the part of the defendant to settle is clearly driven by the terms which they succeeded in negotiating, which do treat differentially Mr. Boies's clients, whether they're class representatives or separately, and absent class members, but that usually comes to us in the form of an objection. And I have a hard time understanding why that was the proper opportunity and we didn't hear that objection.
I think that it certainly could have been raised in an objection. I think we were trying to walk a fine line. We didn't want to disrupt the settlement agreement if we could. We wanted to preserve the one thing to be able to appeal. Hearing now, this is the first time they've ever said it publicly or never said it to a court before. Oh yeah, the settlement is gone.
Well, I kind of figured it out, so
Yeah.
I don't think it was a big mystery, and so here we are.
Yeah, I don't know if that's true or not. It certainly seems clear in hindsight, but we were trying to walk a delicate line not to disrupt the settlement agreement and all the good work and saying we want to step in to preserve this one right, which is to appeal the denial of the damages class. And maybe that was, but the question is, if it could be done, if we could have objected and we didn't, but we're also seeking to intervene at this point, which always happens after final approval, is that legally infirm? Are we legally infirm for doing that? I guess that'd be a question before this court. I don't think so. I think the case law is pretty clear. So even though we could have done both, perhaps, belt and suspenders objected and sought to intervene, assuming the objection would not be taken well by the court. But in any event, I think that procedurally, legally, I think we're in good standing to move to intervene in this context. And I don't agree at all, and it's in our briefing, with their interpretation of Microsoft versus Baker. That's a unique thing when someone settles or dismisses a case with a reservation of rights to revive it later. It's an end run around 1291 and 23F. It makes a mockery of it, and I think numerous cases which have interpreted Microsoft versus Baker said exactly that, including this court in that unpublished decision from a couple years ago, which I cited in our briefs. But we don't have any of that here. These are truly separate parties, no reservation of rights. And so I don't think Microsoft versus Baker has overturned all that history of interveners and standing. And I would just submit that. Thank you very much, Your Honors.
Great. Thank you. Thank you all for the excellent advocacy. The case is submitted. The final case we'll hear today is Ocean S versus County of Los Angeles.
Good morning. May it please the court. Farbad Moradani on behalf of Los Angeles County, the Department of Children and Family Services, and the Department of Mental Health. I'd like to reserve 4 minutes of my time, if that's okay. This appeal is not about whether the state of California or its counties who administer the foster care system should take care of our foster children. The answer to that question is emphatically yes. What this appeal is about is whether a federal judge should substitute his opinion for those of the other branches, state and local governments, and California's juvenile courts on how to accomplish that. The answer to that question is emphatically no. This action fails because the relief that plaintiffs have requested would not remedy the injuries they allege, is beyond the power of a federal court to grant, and would invade the province of California's juvenile courts who bear ultimate responsibility for the well-being of foster children. Starting with redressability. The irreducible minimum of standing requires a plaintiff to show that the relief they request will both remedy their individual injuries and is within the court's power to award, and neither of those applies here. Article 3 standing is based on a single basic idea, the separation of powers. And what is clear, and the Supreme Court has said time and again, is that federal courts have no jurisdiction to exercise general ongoing oversight over the other branches. And that is particularly true when that oversight would be as to discretionary, budgeting, and socio-political and economic decision-making, which is precisely the case here. The administration of a foster care system is an incredibly complex exercise, requiring painstaking decisions about the deployment of scarce resources, about the makeup, frequency, and kind of services to be provided when, where, how, and to whom. These are decisions that are already made every single day by the legislature, by the Board of Supervisors, by the Department of Children and Family Services, people who have devoted their lives and careers to taking care of foster youth are grappling with these issues every single day and must make complex policy decisions about how to administer these systems. A federal judge can do no better than all of these groups combined, and it certainly doesn't have the power to substitute his judgment and take the entire foster care system and put it under federal court oversight for a period of time until the court is satisfied that the foster care system is good enough. These decisions are reserved for the other branches of government. And we are not lacking for guidance here. This court faced a similar issue in Juliana versus United States, where plaintiffs filed suit alleging that their health, their businesses, their properties were being damaged by the government's failure to address environmental change. Just like plaintiffs here, they sought a declaration that the government had violated the Constitution. Just like plaintiffs here, they sought an injunction requiring the government to prepare a plan to correct systemic failures to address these environmental changes. The Ninth Circuit.
But in Juliana, there were other redressability issues of even if that climate change was caused by foreign countries, et cetera. I mean, there were other factors involved, at least based on that Ninth Circuit opinion.
Yes, Your Honor, and those factors apply here as well. So the problem in Juliana was twofold. The first was that the court didn't have the power to grant the relief in the first place because any effective plan would require a federal court to make the very policy decisions that are reserved for the other branches. But the second problem was that even if that remedy were granted, it wouldn't actually be effective relief for the injuries that are asserted. We have that problem here too. The reason we have that problem is there are several. The first is that there are multiple independent actors and independent decision makers who are not part of the lawsuit in front of Judge Cronstadt and could never be. The Supreme Court actually faced something very similar in Halen versus Burkine, where the plaintiffs challenged placement decisions made under the Indian Child Welfare Act. The plaintiffs sued, challenging those placement decisions, and the Supreme Court found that redressability was lacking because those placement decisions are made by state courts. And state courts weren't in front of the federal court, nor could they be, and those decisions are reserved for the state courts. We have the exact same issue here. Every single placement for a foster child is reviewed and approved by a juvenile court. There is a court order stamping its approval on the placement.
How often are the juvenile courts reviewing the placement decisions?
At a minimum, once every 6 months, but it can be much more frequent, and it can be as needed. So every foster child has appointed counsel whose entire job it is to look out for the child's needs and assess whether there are any deficiencies or if there are any gaps. If at any point that attorney determines that there is a cap, they can get in front of the juvenile court ordinarily within 24 hours, sometimes same day.
So I've read the complaint several times. It's written at a very, very high level of abstraction. I've had a very difficult time trying to figure out precisely what it is that we want. So if maybe you can help me. So I understand that one of the principal claims is that we are discriminating against these youth on the basis of their disabilities. Okay. Now, why couldn't that be resolved by a district court?
On the ADA claim, the allegation is that plaintiffs are not receiving placements that are in the least restrictive setting appropriate to their needs. That is a determination that the juvenile court makes every single day. The California Welfare and Institutions Code specifically requires the juvenile court to consider whether...
And if one of the plaintiffs believed that they had not been placed in the least restrictive setting, can that be raised to the dependency court?
Absolutely. That is exactly what they're there for. All they have to do is talk to their attorney. The attorney will request what is called a walk-on. They will walk into the juvenile court and say, there's a problem with my placement. And it's not limited to least restrictive setting. It's any deficiency in the placement. It can be too far from school. It could be it's not a good fit. It could be I'm not getting the services I need. Every single individual injury that is asserted in this complaint is precisely within the province of what the juvenile court exists to remedy. There is no gap here, and that is part of the problem.
So we have some due process claims that claim that they're not being given notice at a hearing because there's been some kind of change in their circumstances for which they thought they were entitled to notice. Can that be handled by the court, or does that have to be handled by an agency? And can any error there be remedied by the dependency court?
Any error can be remedied by the dependency court, but on top of that, that is not something that a federal court can order because we run right into redressability again. The procedural due process claim, the one where plaintiffs are demanding notice and opportunity to be heard, and if you look at the complaint, paragraph 199, they're asking for a neutral arbiter to intervene and hold evidentiary hearings on this subject matter. That wouldn't remedy any of the injuries here because the procedural due process claim is asserted on behalf of foster youth who are renting from private landlords. Private landlords have unfettered discretion to decide who they're renting to. If it's just not a good fit, they can decide they don't want to rent to a particular person. Similarly, if a foster youth violates the rules of their placement, if they violate their lease, as occurred in this case. For example, Jackson K had illicit drugs in his possession and was removed from his placement because of that. The landlord has their discretion to evict someone based on that. Ordering the county to hold hearings about it wouldn't accomplish anything. One, it wouldn't address the injury that's alleged, which is the loss of a placement. That's in the hands of the landlord. And two, it would utterly interfere with what the juvenile court is doing, because if there now suddenly is this third additional branch, this neutral arbiter who is holding evidentiary hearings on whether or not that was appropriate, that inserts chaos into something that is within the purview of the juvenile court.
Let me just ask you a procedural question. So the district court certified this for our review, and then after that, permitted them to amend the complaint. So we have a second amended complaint. I've tried to look at both the second amended complaint and the first amended complaint to try to figure out what survives and what doesn't survive. Some things appear to maybe been split into multiple claims. So is the second amended complaint going to be the operative complaint, or the first operative, the first amended complaint?
The first amended complaint is the operative complaint. So let's walk through this. Plaintiffs filed their original complaint and then amended that as of right. So we have the first amended complaint. The county defendants moved to dismiss that complaint for lack of subject matter jurisdiction and abstention, and various other grounds, including failure to state a claim. And the court granted the motion for failure to state a claim in large part, but rejected the motion to dismiss for lack of subject matter jurisdiction. And all of that is encapsulated within the same order that is in front of you now. Plaintiffs subsequently purported to amend their complaint, and the court had granted them leave to do so. But the court didn't have authority to grant that leave to amend because the court lacked jurisdiction from inception. This court held in Morongo, and it reiterated recently in the LA Alliance case in 2021, that if the court is lacking subject matter jurisdiction to begin with, which is the whole point of this appeal, which is what I am arguing to you now, then every one of its orders, including any of its orders granting leave to amend, are nullities because it didn't have authority to grant leave to amend in the first place.
So if we affirmed the district court's order, then the district court would have the discretion to allow a second amended complaint?
If you affirm that the court has jurisdiction.
Right. If we just affirm the district court across the board, so this would go back. It's going to go back for discovery and trial and further motions and summary judgment. At that point, the district court retains jurisdiction and could then admit the second amended complaint. Is that correct?
It depends on what the amendment is for. So if we're just talking about factual allegations to fill out their causes of action, that would be fine. But if the amendment would be to bring about jurisdictional basis that didn't exist in the first place, then that is not allowed. The Supreme Court.
Why not? I mean, the premise of the question is that we have affirmed it's now back in front of the district court. Why doesn't the district court have authority to, I mean, actually, had already granted leave to amend on some claims, why can't the district court effectuate that?
The district court can grant leave to amend, but you're right. If the court rules that the district court has subject matter jurisdiction to begin with, then it's kind of over, and Judge Cronstadt can grant leave to amend in his discretion.
I mean, I just want to make sure I'm not missing something. The premise of the question, as I understood it, which is a hypothetical, I get it, but it presumed that the case goes back to the district court, and at that point, the district court does what it elects
Correct.
to do.
Yes.
Okay.
That's right. And the interesting thing is your answer to the question on appeal will itself resolve this purported mootness problem. Because if you find that the court lacks jurisdiction to begin with, then it also lacks the authority to grant leave to amend anyway, and it's not moot. If you find that the court had jurisdiction to begin with, then plaintiffs prevail on this appeal anyway, and the mootness question itself becomes moot. So we end up in the same place regardless, which is that the substance of this argument is before you, and that is what the court needs to rule on, regardless of whether or not the amendment itself was correct.
Let me get to some of that substance, and let me be very clear to everybody. I have a degree of skepticism, which I think actually seems to be the district court may at least in part share, with regard to these broad institutional reform class actions. However, there are several of them that have proceeded through the system. And sometimes you can fairly argue that if you focus on all the individual trees, you lose the forest. That is, many of the complaints are not simply, well, in this case, the disability wasn't properly dealt with, but there is a systematic problem so that consistently that turns out to be the result because of some institutional problem. Again, acknowledging skepticism with regard to relief on the merits, why isn't there redressability in the form of relief that might be more modest than what the complaint appears to seek, but still would successfully alleviate or abate some of the problems that are identified in the complaint?
Well, Your Honor, this court just held in Stockton versus Brown, a case that just came out 2 days ago, that it is not the judiciary's job to take up the mantle of imagining a scenario where subject matter jurisdiction might exist. The court takes the lawsuit that is presented to it, and actually that is exactly what happened in Juliana. In Juliana, the court didn't sit there and imagine, is there some lesser version of the relief that is requested here that might potentially pass muster? Jurisdiction is inherently a threshold inquiry. Redressability must exist from the start. It is by intention inflexible and without exception, because the most important question a judge faces in the beginning of a lawsuit is this a case or controversy? So the answer to the question presented to you is that this is not a case or controversy, because the action that is before you now seeks relief that, one, doesn't remedy the injuries asserted, two, is beyond the power of a federal court to grant, and three, would invade the province of juvenile courts. And if I can briefly address the younger abstention question. The district court disagreed with us on younger abstention on one ground, which was that dependency cases are not civil enforcement proceedings. In our view, that is flat wrong. Moore versus Sims itself involved a dependency proceeding. That finding is incompatible with California case law. That finding is incompatible with California case law. Dependency case in a vacuum, that the entirety of the proceeding is one singular case that has to be all viewed together as interrelated hearings. It's incompatible with California statutes that say the dependency court can only retain jurisdiction if it determines that the specific reasons the jurisdiction arose in the first place, being abuse or neglect, and the concerns that are reflected in the criminal statutes, persist. In other words, if a dependency case exists, there is still a civil enforcement proceeding aspect to it. And it is also incompatible with this court's ruling in Bristol-Myers Squibb versus Connors, where the court ruled that you don't look at the specific facts of a specific case and the specific interest in a specific case or the specific component of a specific case to determine whether or not it's a civil enforcement proceeding. You look at whether you look at the general interest in the general class of proceedings that are at issue. The general class of proceedings at issue here are exactly the same class of proceedings that were at issue in Moore versus Sims. They are dependency cases, which the Supreme Court ruled are subject to younger abstention. And I'd like to reserve the rest of the time if that's okay.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Grant Davis Denny on behalf of plaintiffs' appellees. I'd like to start just to clarify one thing about the history of the case. It was actually the case that the district court, when it issued the order that is up on appeal, it granted leave to amend. It gave plaintiffs 30 days to file their second amended complaint. Both parties stipulated to a short extension, and then plaintiffs timely filed that second amended complaint months before the district court certified the 1292B petition. So I just wanted to clarify that fact. On mootness,
It does seem a little odd, and I understand the number of things flowing around, but the certification a substantial time later, without speaking to the question of what complaint we're supposed to be considering, does confuse things some. Though I understand your argument with regard to, well, what do you think we can properly entertain now?
well, I think one way to look at it is to say, let's assume that the Younger abstention argument or the standing argument had merit. Obviously, if they don't, then there was no problem. I think everyone would agree with that. But let's assume that one of those two had merit. Then the question is, did the district court have authority to grant leave to amend, to file the second amended complaint? So take Younger to begin with. The county's position is, no, the court didn't have that authority with respect to Younger because Younger is about a lack of jurisdiction. But the Supreme Court and this court have both made clear that that actually is not the case. Younger is about a decision not to exercise the jurisdiction that Congress conferred on the federal courts. So there's no reason why, even if the district court had found Younger's abstention appropriate, it wouldn't have granted leave to amend, particularly given the nature of the Younger issues here, where it's a lot of it's about how are the claims
Why didn't the
pled.
district court allow this thing to play out, allow another motion to dismiss, if the first motion to dismiss is now moot because there's now another complaint? I mean, I have to say, seems very, very irregular. It certainly has sown a lot of confusion in my chambers. So I'm really struggling to figure out, what are we supposed to do with this second amended complaint? Does it cure problems that I think I might identify? If it doesn't, if it's just the same things but kind of redone, everything's just been renumbered, then I'm not sure what I'm supposed to do with this thing.
Yeah, well, it didn't just renumber things, the second amended complaint. It does make changes. It changes class definitions, it narrows forms of relief, it adds allegations at various points. So there are substantive differences. The second point I would make, though, on that, Your Honor, is that Falk said that even if there are just minor differences between the two forms of the complaints, that doesn't get rid of the mootness issue. The fact is that the filing of that second amended complaint supersedes the first amended complaint.
So what are we supposed to consider?
Yeah, to continue, though, the discussion we were having just a moment ago, turn to standing. Let's assume there was a lack of standing. Well, Jewell versus National Security Agency out of this court says that even when you dismiss for standing, it's subject to the normal rule that you should generally allow leave to amend unless amendment would be futile.
Now, isn't that contrary to what we said in Morongo?
No, it is not. Morongo was a case where the district court had assumed that jurisdiction existed all the way through the district court proceedings. It even reached a decision on the merits. It granted leave to amend, not because it had found a lack of jurisdiction, but because it was granting leave for a party to add a claim in interpleader to the funds at issue. And so what Morongo said was, because jurisdiction was lacking all along, the district court didn't have authority to issue a decision on the merits or grant that leave to amend. It was not addressing what you do when you dismiss based on lack of jurisdiction, or more properly, it wasn't addressing what you do when you dismiss based on lack of standing or based on Younger abstention principles. And that, in Morongo, they cite two authorities for that. The first is a Wright, Miller, and Cooper excerpt that is from their chapter on 1404A transfers. And the statement about if there's jurisdiction lacking, you don't do anything, that was made, if you see the entire quote, it was made in the context of you can't issue a 1404A transfer if the court lacks jurisdiction. Of course, that's true. The other one was a decision where the district court had ordered the parties to either stipulate to the facts or to file an answer. So again, not dealing with the situation that we have here. So unfortunately, I think the appropriate answer here is that this appeal is moot. But I'm glad to answer any other questions the court may have on that.
It's odd because that means the relief for your clients and class just gets delayed for heaven knows how long. I have some trouble understanding how that serves your client.
I don't, Your Honor, frankly, plaintiffs don't like it either. Plaintiffs would rather proceed with getting these issues resolved. But we did feel compelled to raise this issue, and I think it's hard to have a discussion about this case and the fact that you're dealing with both a First Amendment complaint and a Second Amendment complaint without dealing with it.
So if I thought that that there was a redressability problem, not a Younger problem, but a redressability problem or a problem under O'Shea versus Littleton, Rizzo versus Good, those would go to Article 3 concerns, and therefore what? The SAC is not valid?
Not necessarily. I think it so much depends on what is the reason why, Your Honor, in that hypothetical would find that O'Shea applied. It might be that there was some aspect of some injunctive remedy that the court imagined that they thought involved an ongoing audit of the state court proceedings. To be very clear, we're not seeking an ongoing audit. We're not seeking even an injunction against the state dependency court proceedings. But let's just engage in that hypothetical exercise. Well, then the court could grant leave to amend, and in the Second Amended complaint, the plaintiffs could narrow their claim to avoid that issue that creates the Rizzo problem. So that's, I think that's
Okay, but that now would require you to file a different amended complaint than the one that you've already filed?
Well, I'm engaging, sorry, I was engaging with your hypothetical on the assumption that the district court in this case, in this order that's up on appeal, had come out the other way on something like Rizzo.
I'd like to take you to the merits if I can.
Sure,
So
please
let
do.
me tell you that I've read the complaint, the First Amended complaint, a number of times. It's very well written, but it is written at a very, very high level of abstraction. And I have a very difficult time understanding what precisely it is that you want. You want injustices cured, but I'm not exactly sure I know what any of this is going to look like. Sure. So I need you to tell me, why isn't this an ongoing audit of the foster care system in Los Angeles?
Sure. So to begin with, there's, as you pointed out, there's an ADA and 504 claim. One of the key arguments that we make in the complaint is that the county's Department of Children and Family Services has a practice of screening out applications for transitional housing from youth who have mental health disabilities. That includes.
And is this a policy by of the county?
It's a practice of the county. How much
But
it's
not a policy.
How much it's enshrined in a written policy, I think, is subject to discovery,
Okay.
which we obviously
And
haven't
why
gotten
can't
to,
that
but-
be cured on a case-by-case basis in a dependency
well,
proceeding?
In part because youth don't even know whether they have been accepted or rejected from a position. That's another problematic part of the county's procedures, and this goes to the procedural due process claim. Youth submit applications to DCFS and then learn months later that DCFS never even submitted their applications. So there's that difficulty. They don't know. There's the difficulty of not being able to see across different cases to see whether there's a pattern of discrimination occurring. You cannot do that in a dependency court case because discovery is limited to the individual child before the court. But the point I would make, Your Honor, about the systemic remedies here is, I think, is really critical. It's a point that the Fourth Circuit made in the Jonathan R. case. It's the point that Judge Thorne and Judge Henry make very effectively in their amicus brief. When you're talking about systemic problems like this, you cannot solve them on a case-by-case basis. If you go to the dependency court judge and say, I don't have a placement or I need a placement, and the dependency court judge tries to order a placement, they're likely to do so based on a best efforts approach of the county because there is a waiting list. The county has failed to sustain sufficient.
So, all right, so if it can't be done by the court, what is it you expect the district court to do?
The district court.
If the dependency court can't address this, what is the district court going to do?
Well, the dependency court can't, for structural reasons, for example, it can't entertain class actions. So it can't grant system-wide relief. And by the way, well, let me get to your question, then I want to come back to another issue if I could. The district court could, for example, set a requirement that the county develop sufficient number of placements to deal with this population. That would not in any way interfere.
And why doesn't that involve third parties who are not before the court?
The county could provide those placements itself
You
directly.
mean build its own housing?
The county could run its own housing. The
Okay,
county could.
wouldn't that require then a budget allocation? That would be beyond the district court's authority, wouldn't it?
No, there is no absolute rule against that. The Supreme Court has said over and over again that it can be the case that an incidental impact of injunctive relief is.
That doesn't strike me as incidental impact, counsel. That strikes me if you're going to order the county to provide housing you've got classes of several hundred to several thousand. We're creating whole dormitories. These are entire campuses. That may involve easily, hundreds of millions of dollars. That's not an incidental impact. And yet the parties that would have to provide that money are not before the district court.
Well, the county is before the district court. The county is a defendant in this case. And the other point I would just make is that, consider, for example, Brown versus Plata, where the Supreme Court affirmed an order requiring California to dramatically reduce its prison overcrowding problem. In that case.
Yeah, you've got an Eighth Amendment problem there in Brown. That just strikes me as a very, very different situation.
Well, we also have some constitutional issues here as well. But what I was speaking to was the challenge of injunctions having an effect on the expenditure of funds. That clearly was true in Brown versus Plata. It wasn't just an incidental impact. It could have required a massive expenditure of funds on prison populations. And the Supreme Court has said, lack of funding is not a justification for violating people's constitutional rights.
One thing that they could have done in Brown versus Plata is simply let people out. They could grant much, and they did. That was they granted parole in order to reduce the size of the prison population. So California had some options. It wasn't clear that they had to do that. Now, the option here is that California could simply say, once you get to be 16, we're just no longer going to take care of you, and that would solve the funding problem.
Well, there
which
are
doesn't seem like which seems like that would be counterproductive to everything you're trying to do.
Well, I agree. The county, could improve its licensing practices so that it streamlines the licensing process so that it's easier for providers to sign up. It doesn't take months on end or years on end to make it through the licensing process.
And the district court could supervise that or just simply order them to streamline the processing?
Well, yeah, I imagine that the court would start by issuing an order that would require them to achieve a certain number of placements and would give the state and local governments flexibility in how they achieve that, which is what the Supreme Court has recommended.
Go ahead.
That they.
And is the licensing just purely at the county level, or does that also implicate some state baseline requirements?
It's the county certifies at the county level, and then the state performs the licensing function. I'll just note that those state defendants who perform the licensing function are also defendants in this case. So they are not third parties in the sense that has been discussed.
I'm still trying to figure out, as you're describing all of this, how this does not fall within a general rubric of an ongoing audit. That is, you're asking the district court to reform all of this, and it's going to supervise it. It's going to have to supervise. It's going to get reports. It's going to need to know what California has done. It's going to order California to change its processes. That strikes me as a pretty breathtaking undertaking.
Well, I think it's that ongoing audit phraseology comes from O'Shea, right? And that was,
and I admit it's a very, very high level of abstraction. O'Shea's different, so is Rizzo versus Good. I have the same frustration with the Supreme Court's phrase as I do with your complaint. They are both written at very, very high levels of abstraction, and I'm trying to work down that ladder, and I don't know where to go.
fair point. As you say, O'Shea and Rizzo are very different situations from what is at issue here. And it is not uncommon for federal district courts that issue injunctive relief when state and local governments violate federal law to engage in ongoing monitoring. But I think there's a gross overstatement of the amount of supervision that's involved here. We're talking about things like ending discrimination in the way that the county executive branch agencies perform their functions. We're talking about providing notice and due process to these youth so that they don't have this frustration, I mean, that's putting it lightly, of filling out applications only to learn months later that those applications were never submitted. They don't have the frustration of telling DCFS that they wanted to accept a spot, only to learn that DCFS never informed the service provider that they wanted that spot, and they lost it as a result. So there are a number of fairly straightforward fixes here. We haven't talked about Medicaid, but but the states and localities have an affirmative obligation under the Medicaid Act to provide Medicaid services in a reasonably timely manner. This court recognized that in the KDA decision. The named plaintiffs have alleged that they are.
Is there any federal agency that's responsible for monitoring this in order to ensure that California is providing all of the rights that it has agreed to do so under Medicare?
There is the Federal Centers for Medicare and Medicaid. I don't know, Your Honor, the details of how involved they get in examining the provision of services to a target population like this. I just don't know. But anyway, the point is, and one thing I would also say, there's an important decision out of this court, the BK versus Snyder decision, that held foster youth who had brought claims under the Medicaid Act and seeking procedural due process and based on a lack of placements. This court held those claims were redressable. The county only has one response to that, and it's in footnote 3 of their reply brief. They say, well, in that case, the plaintiffs were seeking relief on their individual behalf, the named plaintiffs were, whereas in this case, they are not. But that's simply not true. For each one of the claims, named plaintiffs have suffered the injuries, and a named plaintiff like Onyx G will benefit from the injunctive relief that will be given. Onyx G, for example, has multiple mental health conditions that qualify as serious disabilities. She requested mental health services from the county, but the county failed to provide those mental health services to her. An injunction that required them to provide mental health services to this population would redress those injuries.
Counsel, do your individual clients have, for example, 1983 claims that they could bring?
They may, Your Honor. I haven't thought about that question. This case was purely brought on an injunctive relief basis.
Can you briefly address the Younger abstention and Moore v. Sims?
Yes, I'd be glad to. There's really 3 bases why Younger doesn't apply. And I think the first and most basic one is we do not seek to enjoin any state dependency court proceeding. And the injunctive relief that I've described throughout the course of the argument would not in any way interrupt those proceedings. It wouldn't enjoin them. And remember, Amerisource-Bergen says it needs to be an actual or effective injunction of the state dependency court proceedings. The mere potential for conflict isn't enough. Sprint says that the mere possibility that they could issue decisions on the same subject matter isn't enough. So, no injunction. That's reason number 1.
Wouldn't the district court order essentially preempt the placement decision of the juvenile state court proceedings?
No. Dependency court judges could go on approving the placements just as they always have at those 6-month hearings. The district court wouldn't overturn those dependency court, wouldn't second guess them. It simply would address the issues that the executive branch agencies have engaged in. Discriminating at the application stage, which is not something that the dependency courts are involved in, providing procedural due process at the application stage and at the push-out stage, which is not something dependency courts are involved in. And so, no, I don't think it would in any way interrupt. I'll just note there are 2 other reasons why Younger doesn't apply. I'd be glad to address them, but I see that I'm out of time. Thank you.
Great, thank you.
Your Honors, the operative pleading in this case is the first amended complaint. That is the complaint that exists because plaintiffs amended their original complaint as of right. After that point, no further amendments were allowed because the district court lacked jurisdiction. Morongo is clear. This court has reaffirmed the Morongo rule multiple times, including in Ashker versus Newsom and the LA Alliance case, that if a court lacks jurisdiction to begin with, which is the allegation and the argument here before you, every one of its orders, including its order granting leave to amend, is a nullity. So you should treat the second amended complaint as not existing, the same way as if a plaintiff just unilaterally filed an amended complaint because
Well, it's not unusual if a motion to dismiss is granted by the district court, or for that matter, on appeal, there is commonly leave to amend if an amendment could address the problem. So I'm not entirely sure. I mean, you're true. If we decide, nope, there's just no jurisdiction here, yeah, that will end the matter, but then we don't have to worry about, could the complaint be amended? So I'm not sure why you're emphasizing we're not supposed to look at the second amended complaint. I don't know that that really matters here.
the reason is that the complaint cannot be amended to correct lack of jurisdiction.
Oh, so the point is you're claiming there's a lack of jurisdiction. I'm not sure what the existence of the second amended complaint has to do with that.
That's the point. We end up looking at the first amended complaint regardless. Talking about whether or
Oh,
not
no, that part's not true. Because if it's amendable to correct the problem, you have to consider, is it amendable? And the second amendment complaint might shed light on that. Your point is that neither one of them solved the jurisdiction problem.
No, Your Honor, our point is you don't even get to the second amendment.
No, that is simply not right. If the complaint could be amended to solve the jurisdiction problem, then it's common to grant leave to amend. If the second amended complaint is an exemplar of what could be done to amend, and it does solve the problem, we're entitled to look at it to decide if it could solve the problem.
But Your
What's
Honor,
wrong with that?
because the Supreme Court ruled in Newman versus Green that that is not permissible. If
We're
jurisdiction...
entitled to consider whether an amendment to the complaint could solve the problem. Is that correct?
No, Your Honor. Because
So we have to dismiss no leave to amend, period? We
in-
tell district courts all the time they can't do that.
if the issue is that the subject matter jurisdiction was lacking to begin with, then you don't even get to the second amended complaint because leave to amend was not permissible.
Unless an amendment could solve the jurisdiction problem.
And the only scenario where that is possible is if the amendment is solely as to pleading. With respect to whether or not there would need to be an ongoing audit of the juvenile court, that is clearly the case. And every single court of appeal, except for one that has addressed this issue, has found that there would need to be, and that requires younger abstention. The 7th, 8th, 10th, and 11th circuits have all considered this issue, and they said that regardless of whether or not you're directing relief specifically at the juvenile court, effectively, a federal court would have to exercise oversight over the specific decisions made as to placements, as to medical services, and as to everything else in order to determine whether or not the relief that is granted is actually being complied with. Therefore, younger abstention is necessary here. Thank you, Your Honors.
Great. Thank you, everyone, for the helpful argument. Case is submitted, and we are adjourned.
All rise. This court for this session stands adjourned.
those deadlines are passed, as it was here, then Rule 16 says good cause has to be shown.
That presumes that you need to amend the scheduling order to amend a pleading. And I
Counsel,
don't
what
believe,
is our standard of review for this issue?
so this is a abuse of discretion review, I believe, but because Dr. Gonzalez is raising a legal issue, you essentially review that de novo.
What is your best authority for the fact that we would review this in any way de novo?
Sorry?
What is your best authority for arguing that we would review any portion of this particular claim of yours de novo?
Oh, that this is an error of law, and therefore is a question of law that the court reviews de novo.
But the compliance with the scheduling order is a discretionary decision that we give district court judges, isn't it?
I believe that is correct, Your Honor. The district court has discretion in setting the scheduling order and whether to amend it. However, the presumption that you necessarily have to alter the scheduling order before you can amend a pleading, just because the scheduling order deadline has passed, I don't see any basis for that in Rule 15 or Rule 16.
Right, so my point in asking you about the standard of review is here, the district court determined that there was a failure to show diligence. That determination, it must be reviewed on a abuse of discretion standard.
Correct, but the court made that determination under Rule 16 rather than Rule 15, and those are very different standards. So Rule 16 standard.
I still am not sure I understand why you think Rule 16 doesn't apply when Rule 16 authorizes a scheduling order. A scheduling order was issued here, and it set a deadline of August 2020 to amend the pleadings, and then she seeks to file the amended complaint in May of 21, which is after the deadline set. And so therefore, it requires an amendment of the schedule, which Rule 16 says requires a showing of good cause. Where am I making a mistake?
The gap is that amendment of a scheduling order is separate from amendment of a pleading. While the court has issued
Not if the scheduling order has a deadline for amending pleadings. Then you have two, you can have two rules that are implicated in the same. We have rules about discovery, and those are governed by other rules as well, but it doesn't take them out of Rule 16 to have deadlines.
I don't disagree with you, Your Honor. I think it's a factual question that Dr. Gonzalez is only seeking amendment of her pleading rather than the scheduling order. So you have to graft Rule 16 onto Rule 15 standard in that instance.
I just can't imagine a world where, as an appellate court, we would have to be reviewing all of the decisions de novo on amendments of the scheduling order. I mean, that would be a nightmare.
Perhaps I misspoke when I stated de novo review. What I meant is that this is a question, Dr. Gonzalez is appealing the court's application of this rule that Rule 16 even has to apply. That's a question of law, whether Rule 16 applies when you move to amend. So I acknowledge that Rule 15 is generally an abuse of discretion standard. I'm saying that because the question specifically presented on appeal is a legal question and a pure legal question, that you would review that legal question de novo. And I apologize for any misunderstanding. So the reason why you have those separate documents, the scheduling order and the amended pleading, and why there's no reason that you necessarily need to amend the scheduling order to amend a pleading is because Rule 15 has this very comprehensive scheme that addresses amendment of pleading before trial and after trial. Now, as a logical basis, you realize that the scheduling order's deadline for amending pleadings is going to pass at some point. It's a mandatory requirement entered in every case pursuant to Rule 16. That said, we have a separate standard under Rule 15 that you can amend after trial. And importantly, Rule 15B2 states, in part, when an issue not raised by the pleadings is tried by the parties' express or implied consent, it must be treated in all respects as if raised by the pleadings. But failure to amend does not affect the result of the trial of that issue.
Counsel, I'm going to ask you to switch gears here for a moment and on the issue of the acknowledgement of the indebtedness. I'm curious to know why the May 2019 email exchange wasn't admitted as an exhibit at trial.
It was a tactical decision, Your Honor. we were evaluating the evidence. We decided that the cleaner and simpler document to use was simply the June 2019 offer letter. Returning to Dr. Gonzalez's discussion of the motion for leave to amend, aside from Rule 16 providing this comprehensive standard that doesn't address scheduling orders, you also have the issue that there's going to be an inevitable conflict between Rule 16 scheduling order and the good cause requirement and amendment of pleadings after trial, right? That there's always going to be some issue there. So you're going to have to reconcile these two standards. And you don't even need to reach that far because Dr. Gonzalez's appeal, which was not, or sorry, her motion to amend, which was after the scheduling order's deadline, but not before the trial, had that because justice so requires standard. And under that standard, the party opposing amendment bears the burden, and importantly, that amendment cannot be denied solely because of delay. This is the DCD programs case, 833 F2D. I don't have the exact site. On the contrast, Rule 16 places the burden on the party seeking amendment, and it can be denied solely because of delay. So those are just mutually inconsistent standards. So if Dr. Gonzalez was going to succeed on her motion, she would have had to satisfy Rule 16 standard, the burden placed on her. Meanwhile, the network would have never been able to satisfy its burden under Rule 15. So I just don't see why you would impose those two standards when they're going to conflict with one another. Because essentially, by saying the scheduling order and Rule 16 are always going to apply, you're going to invalidate Rule 15, which doesn't make sense because the scheduling order is going to be in every case. Turning to Dr. Gonzalez's other arguments on appeal, her retaliatory termination claim, there are three kind of key thoughts to keep in mind. First is that the network had this future funding rationale, which it's provided absolutely no evidence of. The district court noted that it was distinct, that the bases for that rationale were fundamentally distinct from the rationales that the network tried to paint as the same rationale. And that raises the question under the Villarimo case, whether the network retracted it. Now, there's a jury question on that simply because the network provided absolutely no evidence in support of it and instead pivoted to different reasons. So having established that, we look at that when the network asserted that rationale. That was the September 2019 phone call. The very first time that the network informed Dr. Gonzalez of its termination decision, and at that time, the termination decision was final. So we have to ask ourselves, why did the network come up with a faulty reason when it purportedly had all these others? And that creates the causation question that gets to why the Sarni case really matters here. Because in Sarni, the employer had knowledge of existing prior issues. The employee made a complaint, and then the employer decided that those were fireable offenses. And that's the real question here, is that Dr. Gonzalez made her arguments that, she complained, and then all of a sudden the network changed its position on all these other circumstances and found a reason to terminate her. And the reason why a question of fact exists on all that is because the pretext inquiry is focused on the reason for the network's decision. So it may have found that there were...
Didn't you waive your argument about the motivating factor standard?
No, Your Honor. The motivating factor standard was affirmatively argued by Dr. Gonzalez to apply during the summary judgment briefing. The district court misapplied that standard. And
Can
that
you
is,
point us to that? I don't know if I found that. But at some point, maybe in rebuttal, you can.
you want to, where Dr. Gonzalez raised the motivating factor standard
Right.
at summary judgment? Okay,
No, in front of the district court,
Oh,
sufficiently
in front
such
of
that
the
it wasn't
district
waived.
sure. So that motivating factor standard, as stated in Zarni, is that you can have a substantial motivating factor, but not the sole reason for the termination. So that also gets to the point that even if the network found these reasons to be valid reasons, you still have to look at why they asserted them in the first place. And the record is replete with numerous instances of the network having bases, but then proceeding to not take any action. And in fact, taking action contrary to their belief that they thought those were terminable bases. Most notably, the June 2019 offer letter itself. So considering the fact that, this financial stewardship, these past funding rationales already existed at that time, the fact that the network is now asserting them having presented an offer letter after knowing they existed just fundamentally begs the question of why was it fireable? Why wasn't it a fireable offense then? And in fact, we were willing to contract with Dr. Gonzalez, but after she complained, suddenly it's a fireable offense. So Dr. Gonzalez also raises the issue that if she presents pretext as to some of the network's rationales, then there is a general question of credibility. I think that issue is heightened by the fact that the network is relying on generally past or events that had occurred prior to the termination decision, as you would expect. However, they didn't raise those as fireable offenses until after Dr. Gonzalez terminated her. And then you have to look at the question that when they had the opportunity to assert those reasons, they instead made up the future funding rationale for which they had no basis, which cast doubt on their assertion of all those other after-the-fact offenses. And this is kind of gets the real key faulty issue in the district court's logic.
Now,
Because-
I thought I'd heard you said you wanted to save 8 minutes for rebuttal, because it looks like you're within that time. You can keep going, it's your time.
No, thank you, Your Honor. Thank you.
I, for one, would like you to address the focus order that was provided by the court to.
Certainly, Your Honor. So Dr. Gonzalez's position is that the network's appeal of summary judgment presents a sufficiency of the evidence question. In fact, the headlines or the headings for their arguments, in fact, say this is Dr. Gonzalez, the May
So you
2019.
agree it's barred by Ortiz?
Yes, that would be my position. I would also add that Ortiz has mentioned that, the issue of acknowledgement of the just debt went to trial regardless. So that factual record has been developed. There's no reason why reversing the decision at summary judgment would have any impact on that. It wouldn't even be issue preclusion. So I'll reserve the rest of my time.
All right, thank you, counsel. So we'll hear next from Mr. Leonhardt.
Good morning, Your Honor. May it please the court, my name is Shanks Lenhart. I'm from the law firm of Sanders and Parks. With me is my colleague Vincent Miner. We're counsel for the appellee and the cross appellant in this matter, the U.S. Human Rights Network. Let me start by addressing the issue with the focus order. This court can and should review the denial of summary judgment. I know that is an unusual.
How can that possibly be true under Dupree and Ortiz? There is a different factual record at summary judgment, and that's denied, and then it goes to trial, and there's a different trial record on the issue, and then there's a J-Mall motion with respect to that. Exactly what Ortiz and Dupree say is that we don't care about the summary judgment record, which may have been different. It's superseded by the trial record. It's not appealable, not reviewable. How do you get around that?
So I agree with Your Honor that that is the general rule, and our
And
position
you
is.
seem to be within the general rule.
Well, that we probably disagree with, Your Honor, on respectfully. Our position, Your Honor, is that the denial of the motion for summary judgment on the application of a savings statute of limitations defense was a pure legal decision. We've argued that throughout the case that the judge needed to make that decision as a matter of law. And so if you look at the Dupree case, which is.
Why you need to hang your hat on this particular argument that I think you're making with respect to the statute of limitations if at the J-Mall stage, you have insufficiency of the evidence based on the failure to have admitted what appears to me to be a pretty important email, the 2019 email, into evidence. And so relying entirely on the J-Mall record, I think you get to the same place.
I don't disagree, Your Honor, and I don't want to give this court the indication that it's a binary position, that it's one or the other. We argued obviously both. We did file a Rule 50B motion. Our position is, as Your Honor noted, that the evidence presented at trial was insufficient because the appellant failed to introduce the May 19 email, which contained the "I'm sorry, getting you up to speed" language, which Judge Lanza had identified as reflecting the justness component or the moral obligation. So absolutely, Your Honor. I think as an academic exercise, I believe that you can decide this at the summary judgment level under the Dupree case, but I agree that you can and also to decide at the
You characterize it as a
J-Mall.
legal question, but it's a legal question where the facts matter, and the facts that are in the record matter to the determination of that legal question, correct?
Yes, Your
And
Honor.
ultimately, it's summary judgment where district court can't make factual determinations. It's just an assessment of whether or not there is sufficient evidence under the legal standard to meet the standard. And so even though it's a question of law, ultimately, it's still governed by Ortiz.
Sure, Your Honor, and I
Maybe you
think.
tell us about why you think the J-Mall, you
Sure,
should win
Your
on
Honor.
the J-Mall issue.
I think the J-Mall issue, as Judge Desai has pointed out, the evidentiary defect at trial was the failure to include the critical email that the trial court had relied upon in denying the summary judgment motion, and that was the May 2019 email. That's Volume 3, Excerpt of Record 476. That's the email that had the apology language in it. Again, our position is that even that email was not enough, but certainly when you strip the other writing that is cited, which is the conditional job offer, away from the May 19 email, you lose the justness or the moral obligation piece of it. And what you're left with is simply a letter stating, we'd like to offer you a job. If you'd like to take that job, please sign below and accept that offer. And the evidence in the trial record was undisputed that the plaintiff never accepted it, not by signature, not by phone call, not by anything. So our position is that the evidence on trial was deficient because it didn't satisfy those elements you need to establish that saving statute under 12508, right, which is that there is a sufficient identified obligation, that it contains a promise, and that it contains an expression of the justness of the debt. And the job offer letter does not contain those particular elements. And so that was the basis for our Rule 50B motion, and the basis for our appeal on that is that the evidence should have warranted a judgment as a matter of law on that issue, Your Honor. Let me address just briefly the issue of the motivating factor. I agree with this court that was not raised to the trial court. It was not raised in a motion for reconsideration. It was not raised in the Rule 59 motion for new trial. The issues that were raised at the Rule 59 stage in the motion for new trial had to do with whether certain evidence at trial demonstrated evidence of pretext, so that the causation standard was never applied. Secondarily, this trial court didn't grant summary judgment on causation. It's not a causation case. It's a pretext case. And the pretext analysis, which both sides agree here, is governed by McDonnell Douglas. And, Arizona has applied McDonnell Douglas to AEPA claims, which is what this claim was. And, if you look to the Burdine case, the U.S. Supreme Court, that gives us the roadmap for how to look at an appellant like this that's going to try to prove pretext in the face of legitimate non-discriminatory reasons based on circumstantial evidence. And it's got to be specific and it's got to be substantial. And so the court went through and analyzed each of the legitimate reasons that the network provided and demonstrated that plaintiff did not rebut those with specific and substantial evidence. The Zarni case that's referenced strongly by the appellant is not instructive. It's it's an intermediate unpublished appellate decision in the state courts here. And number two, it cites and relies specifically on the United States Supreme Court precedent and this court's precedent. So I would, encourage this court to look for the answers to the questions on whether pretext has been demonstrated by looking to this court's decisions that flow from Burdine. The Villarrealmo case is one, the Colgan case is another, and we cite those in the brief, and the trial court addressed those in the decision. The issues pertaining to the allegations of shifting reasons, to be honest, Your Honor, are, and we argued this at the trial court, they're largely semantical. They're a difference in authorship. So you have an executive or a board member that writes an email that says one of the reasons that we're moving on from this executive director is due to a spate of claims by former employees. There had been 3 grievances filed and for the appellant, when one of which is she terminated a subordinate who was on maternity leave. generating an EEOC complaint. So that was referred to as a spate of claims. And then what's being argued here is that when my law firm filed a motion for summary judgment, and we put a heading in there and we said one of the legitimate reasons for the this was for the grievances, that wasn't the exact same language used in the spate of claims. And the trial court properly found that not to be a meritorious argument. The shifting rationale or the shifting reasons would be, fundamentally different reasons than were presented, not just because one author describes this way and one author describes it that way. So again, our position is that the trial court did properly evaluate all the issues related to pretext and determined that those did not reflect that specific and substantial evidence that Burdine requires and this court requires. As it pertains to the motion to amend issue, what's being argued here is a very novel argument that sounds like is asking this court to reshape the rules of civil procedure and decades of precedent in the Ninth Circuit. I don't think the court needs to even entertain that analysis to make a decision here. If you read the judge's order denying the motion to amend, I would submit to you that it absolutely complies with Rule 15 as well. It cites the undue delay. It cites, which is a ground under Rule 15, of course, to deny. And again, as this court has pointed out, it is an abuse of discretion standard. And really, the issue of prejudice is a little bit of a misnomer here in some of the arguments that the appellant is making, because if you look at Rule 15, it talks about prejudice, but it also talks about bad faith, and it also says or undue delay. So it's kind of an or situation. The Lockheed Martin case, which we cited, is very instructive. It's very similar facts. That's 194 Fed 3rd at 986. And again, we would submit to your honors that as it pertains to that issue, that the court absolutely complied with the rules, whether it's under Rule 16 or Rule 15 under abuse of discretion.
What's your response to his point that, if Rule 16 can be invoked to set hard pretrial deadlines for amendment of the pleadings, that renders nugatory the whole provision of Rule 15 about amendment during trial?
Yeah, I understand that the framing of that argument. I guess my objection to it would be, number one, it's not been recognized by any court in the United States that I'm aware of, nor the United States Supreme Court or any sister circuit or this court. This court has continually applied the Johnson rule from 1992 for decades. And I think that if you go back and read Johnson and you understand the basis for it, it's absolutely logical. If you're going to amend a scheduling order, you have to demonstrate the good cause to do that. The other reason that I don't think the court needs to, really entertain any of these issues about, the interplay of Rule 15 and 16 is that, this appellant chose upon the denial of the motion to amend to refile that action. So she could have waited, had her trial, come before this court and said, my motion to amend was denied, it was abuse of discretion. That's not what she did. She went and filed a new lawsuit. That lawsuit was then dismissed with prejudice on Rule 12b-6 and for failure to state a claim, and then that was appealed to this court, and that appeal was abandoned. And so for that other reason, there's no way to revive that claim that's been dismissed with prejudice. That judgment is final. You can't revive that claim through a motion to amend in this case. So that's another separate reason why we don't need to entertain the Rule 15 or Rule 16 type analysis. The final thing I want to touch on, and I'll reserve the 5 minutes of my time, is when it comes to the issue of the acknowledgement of the debt.
We don't go back and forth on cross appeals. You have one block of time now.
Oh, I'm not going to reserve?
No,
Okay,
it's not like
perfect.
the briefing.
Thank you for the clarification, Your Honor. I'll keep trucking.
Tell us everything you want us to hear now.
I'll keep trucking. Thank you. On the issue of the cross appeal, we talked a little bit about already the acknowledgement of the debt, but there's another element to the cross appeal, and that has to do with the continuous violation doctrine. So at trial and at summary judgment, the court, although it was really more at trial that this came up in the post-trial, or I guess a final trial briefing, this issue of, okay, if the court were to find that the acknowledgement of the debt was insufficient, would there be an accrual continuing for every pay period such that the statute of limitations would only bar the first 3 months or whatever it was before the 1-year mark where she filed her lawsuit? And I wanted to touch on that briefly because that is in our briefings. The continuous violation doctrine is a doctrine that has been applied to easily divisible type contracts. The seminal case is a case called Builder Supply, had to do with trucking different loads to different zones in the city, and depending on what zone you went into, the truck got paid a certain load calculation. And the facts of that case were that there was a number of years where the one delivering the loads or the one paying, I can't remember which, it's not material, was paying the wrong rate. And that went on for many years, and the court looked at that and said, well, we're not going to bar the whole thing, even though you knew or should have known, years ago that you were getting charged the wrong rate or paying the wrong rate. This is an easily divisible thing, and each time the load goes into here, it's a new breach. That's the primary basis by which the court found here that there was a continuous violation. Our position is that has never been applied in an employment context. The issue that was at issue with the breach of contract related to an oral contract that the jury found was made in December, January of 1819. And the ideal was that starting January 1, the appellant would become a full-time employee entitled to benefits. And the evidence was undisputed at summary judgment and at trial that the plaintiff was well aware, starting January 1, 2, 3, 4, all the way, that she was not a full employee and was not receiving all of her benefits. So our position is that is a breach at that point in time. And the fact that she continued to work there for 11 months, which she happened, that person was never made a vice president, and then it went beyond the 1-year statute of limitations. They filed in the court in that case, that's called the Day case, determined that was time barred. So that is the continuous violation doctrine. Unless the court has any other questions for me.
I have just a quick question on
Sure.
your argument with respect to Builder Supply. I know you're arguing that it did not, that case did not arise in the context of an employment issue, but didn't Builder Supply cite several cases from other jurisdictions that applied the continuous violation doctrine to wage payment claims?
Yeah, I think Your Honor, that's a good question, and I do recall that there may be decisions that would apply it, and there's been, I think, one of the ones the trial court relied on was the Damasi case. But in this context, we've argued those are distinct. So those are hourly cases. So, there's a principle in employment that day's wage for day's work, right? Those cases talk about that in the context of an hourly employee, meaning, the idea is that, you're an at-will employee, you work here today, you get paid for today. There's no guarantee you're working here tomorrow. That's the basis for that type of analysis. We think this case is distinct. This is not an hourly employee. This was the highest ranking executive of the network.
But why isn't the logic of it applicable here?
Sorry, I didn't hear you.
Why isn't the logic of it applicable here?
Well, because in this situation, the decision or the failure to make the appellant the full-time employee was a singular event. It occurred in January when the appellant was not made a full-time employee. So that's the breach. There's not a subsequent breach each pay period. Again, we analogized it to the Ancala case, which is an unpublished case, but it's related to the management of a golf course. You weren't managing the golf course properly. You're not managing it properly on day 1, day 2, day 3, day 4. It doesn't create a separate individual breach. The breach is when you learn that's not being properly managed. And that's the basis for our position that here, it's more akin to the vice president or the golf course management. It's a singular event where the plaintiff knew as of January that they were not being put in this full-time position as a permanent executive director, and it was incumbent upon them at that point in time to bring that action within 1 year. So, any other questions? Thank you for your time.
All right, thank you, counsel. We'll hear rebuttal.
I'd like to return to Judge Desai's question about where Dr. Gonzalez raised at summary judgment the applicable standard causation. That was 2 ER 244. It's actually raised in dispute, or sorry, the network's position that a but-for causation standard applied, so this was squarely before the court.
Wait, I thought you argued it in the motion for reconsideration.
We argued it in the summary judgment motion.
I thought that in your brief, your yellow brief at page 3, you said Dr. Gonzalez did not waive her argument by not raising it at summary judgment.
Oh, sorry, Your Honor. That is specific to the court's misapplication of the motivating factor standard, which only happened because the court misapplied it.
That's what you intended to say there.
Yes, yeah, the court misapplied it, so Dr. Gonzalez could not have raised it at summary judgment. So she did not waive it by not raising it at summary judgment because she could not have.
I see your argument now. Thank you.
Returning to opposing counsel's continuous violation argument, I agree with Judge Desai that the Builder Supply Court cites employment cases from out of state. There's also...
But what do you say to the argument that your friend on the other side made that it's still distinguishable and it shouldn't apply in this context to the highest executive of the organization?
I would say that there's no foundation for the network's argument because this was an at-will employment relationship that a day's work created the new contract. So every day there was a new contract. I know that's very much a kind of legal fiction, but it is the way that the law works, and that's what matters because accrual of a breach of contract cause of action requires both the contract, the breach, and damages. And Dr. Gonzalez certainly didn't have any damages until the day that she actually performed the work and would have been entitled to those benefits. Now, regarding the Day versus LSI case, that case just doesn't even apply. It doesn't address the continuing violation whatsoever. In fact, the employee in that case didn't even oppose the statute of limitations. So it's the decision just has very little relevance. Regarding the Ancala case, that case one was golf course management, but separately it's also a Ninth Circuit unpublished decision, so it's not binding. And it's definitely not indicative of where Arizona law would be, particularly on the issue of at-will employment. The Damas case really sets that out very clearly, that at-will employment relationship, which this was, they don't contest that, is formed every day, and because of that, you have a new contract every day. Now, regarding the acknowledgement of the just debt, I'm going to focus on the June 2019 offer letter, and I'm going to be very clear that the network we have two diametrically opposed factual situations here. The network believes that there was no oral agreement, and therefore this June offer letter was just whole cloth, a new offer letter. If that was true, why is it dated January 2019? There is absolutely no explanation for that. The only reasonable explanation for that is that the network realized that they had an obligation to employ Dr. Gonzalez as of January 2019. Now, there's a factual dispute about whether or not there was an oral agreement. The jury found in Dr. Gonzalez's favor on that issue, but the network still contests it. But regardless, if Dr. Gonzalez viewed that there was an oral agreement and there's no other explanation for the January 2019 language, then that's a reference back to her oral agreement. Secondarily, I'm going to direct the court to the In re Weaver case, which is a decision by this court that addressed the justness element of the 12-508 requirements. And it says that it's really a know it when you see it sort of situation. There doesn't have to be anything there. And in particular, Weaver, as well as Sladkey, more or less decide that the justice element exists because the opposing side does not push back. So the fact that the network has put forth this document stating, yeah, this is like the terms of your employment, all the benefits you were going to have, it's backdated to January 19, and there's
How could
really
a
no.
reasonable juror read so much meaning into the date of the letter?
Well, what other explanation could there be, Your Honor? I don't believe I'm overreading it because I can't think of another logical explanation for it.
Well, I mean, I guess part of my difficulty here is that you wouldn't have had to rely on that had you had the May 2019 email in evidence.
I mean, according to opposing counsel's position, I would have, but regardless, I don't see how the absence of the May 2019 letter does anything because the June 2019 letter contains the required elements. It's in writing, it's signed based on the signature or the email, at least that's not contested on appeal. It references the January
You're
oral.
talking about the June 2019 email now?
Sorry, the June, well, I referenced that for the signature requirement under 12508, which is not an issue in the cross appeal, but that's what was argued at the trial, or at the district court level. So regarding the reference to the prior agreement, again, there's no other explanation for the January 2019 language. According to the network's own viewpoint, there had to be a signed written offer letter before any agreement could be formed, which means why is this document backdated to January 19? Under their own theories of the case, there is no explanation for why it's backdated. Dr. Gonzalez offers that the only plausible explanation is because of the oral agreement. I see that my time is up. There are no further questions.
All right, thank you, counsel. We
Thank you, Your
thank
Honor.
counsel, both sides for their arguments in this case. And the case just argued will be submitted, and this court for this session stands adjourned.
Ninth Circuit will now depart. This court for this session now stands adjourned.
Welcome to Bigo, where connections come alive. Anytime, anywhere.
There was a time when the Blue Ridge Mountains burst into color. It was fall, this fall at Biltmore. Plan your visit or overnight stay today.
Assault, and you fought with the officers. You're not big enough to take me to jail. He had to be physically picked up and placed in the back of the patrol car. I guess he was.
Your Honor,
Don't say any more about that. Not at this point.
Don't make any statements, sir.
I'm gonna set the bond at $2,500, cash or surety. You are to personally appear for any and all court hearings, abide by any judgment entered by this court, and serve any sentence imposed. You're not to leave the state of Michigan. Do not commit any crime when released. You shall provide information and telephone number upon release, and you must contact the Office of Community Corrections by telephone, and the number's on the order the very next day if you get out. And I want electronic monitoring supervision. Do not harass, intimidate, molest, or threaten the complainant, Melissa Barker.
Is to assign a rate to every class of business.
that is sufficient to generate an appropriate rate of return for that class of business. In other words, we don't want, say, homeowners on the coast of Georgia being subsidized by people who live somewhere in the northern part of the state, for instance. So for that reason, underwriting is used, and we use different, so for instance, so the distance away from the coastline would be an underwriting factor that would help ensure that those rates are appropriate for people who live in one area versus another. So the idea is to have a rate that is appropriate and truly reflects the risk. And so, yes, generally speaking, an insurer will look to generate an underwriting profit, and particularly in a low interest rate environment, they will need to generate an underwriting profit because you're not generating that much off the investment income side. Even so, let me give you a sense of the overall property casualty insurance industry. Last year reached $1 trillion in terms of total revenue for the first time ever. The investment income earned by the industry last year was somewhere in the vicinity of 60 or $70 billion. Okay, so it is a fairly small proportion relative to the premium that is actually collected to pay the ultimate losses. And so insurers also cannot assume that investment results that we saw in the last couple of years are going to be there in the year ahead. So for instance, 2022 is a very good example of this. In 2022, we saw a lot of unanticipated inflation, which was jacking up the claim severities. At the same time, they saw the value of investments fall as the stock market tanked and interest rates took a while to get up to where they ultimately were where the Fed was raising them. And so it took a while for insurers to generate additional investment income. That's a very slow process. So insurers do not operate under the assumption that they are going to be able to offset fully or completely any losses on the underwriting side, on the investment side. They can't operate that way because no one can know what the future state of the investment markets is going to be over long periods of time. The way I explain it to my students, all else equal, over long periods of time, if interest rates are persistently higher, rates can be lower than they otherwise would be in a low interest rate environment. But again, generally speaking, they're going to operate such that they need to generate some form of underwriting profit, particularly in so-called short tail lines, which would mean auto and home, where there's not a lot of opportunity to generate investment income. Much of the investment income is generated in lines of insurance where the insurer takes in the premium, but the claims may not be paid out until over a period of years. Something like workers' compensation is a good example of that.
Thank you. I have one other quick question.
Sure.
Not really related to what you talked about, but I think you're very clued into this. What's a reasonable amount of time for an insurance company, in your mind, to approve or deny a claim for someone? Is there a standard out there for like, hey, a reasonable amount of time?
I believe that states, and probably somebody here could better answer this than I could, most states have a certain number of days where the insurer has to at least acknowledge the claim and take some initial actions on it. And I believe that's determined by statute in most states.
Well, outside of statute, because statute is made by us. You're a professor in the insurance world. What do you believe is an adequate amount of time for an insurance company to review a claim and make a decision?
In my experience, for instance, I've seen enormous variations in what I would consider to be appropriate. So, for instance, in the case of a sort of a plain vanilla type of fender bender auto claim and kind of a small personal property claims, something like this, you're usually going to have the policyholder is going to call within the matter of days to initiate the claim, and the insurer is going to respond to that almost immediately, usually sometimes immediately within a few hours, or certainly within a few days. During times when we have, how many claims did I say? 175,000 claims like a Hurricane Helene. It can take a bit longer for an adjuster to come out in part because obviously there are 175 claims over the span of a couple of days. Adjusters are being brought in from the state. But again, even my personal experience, I had my first claim ever with Helene, even in South Carolina, and I was able to I was able to speak to the insurer within 24 or 48 hours, and an adjuster came out about a week later in my case. And I was very happy with the way that it proceeded in my case.
So say outside of a catastrophic event, I'm not sure how often Helene's going to come through Georgia. Hopefully not often. 90 days, 60 days.
Yeah, I can't say, I don't have enough familiarity with, and I think statute is important, but I think, and also the mix of claims. For instance, I did a lot of work in New York on auto claims. And in that state, we only had, for instance, 30 days effectively under the law originally to close a ordinary auto claim. The problem is that fraud was absolutely rampant in the state. And what would happen is the claims would intentionally be tied up by unscrupulous attorneys and unscrupulous medical providers who would then attempt to sue the insurers for bad faith because it would take longer than 30 days to close the claim. In those cases, the insurers had a valid point in the sense that they were lobbying for 60 days to be able to adjust the claim appropriately. I think in that period of time, they wound up getting it up to 45 when there was strong suspicion of fraud. So it is claim dependent. And so I can't give you a firm answer here other than what is sitting in the Georgia statute.
All right, thank you.
Thank you, Professor. All right, let's turn back to the national slide, the slide with the map of the nation. I thought that was good to see sort of the big picture. Let's leave that one up there if we can rewind to that. But Professor, I really appreciate your testimony. Thank you for coming.
Okay, good. Thank you.
Really, really enlightening. All right, our next witness is going to be Ms. Hesselmeyer with DECRA. If you can make your way up here while you are, do we have Chairman Bruce Williamson online? Chairman Williamson, feel free to introduce yourself.
Well, hey, yes, this is Bruce Williamson. I'm the state representative for House District 112 and Walton County, Georgia. And I too enjoyed the presentation. It took me a minute to get the Zoom working, but I was, anyhow, glad to be in the meeting.
Thank you, and we appreciate you joining online, and we know your many years in the insurance business will help us greatly on this committee. And Representative Williams, you had something from someone from McIntosh County who was going to come but got sidetracked. So tell us what we're going to get from him.
I have a letter from Chris Harper, who's the Senior Vice President of Southeastern Bank, and he's outlining several things. Sorry he couldn't be here, but he had a funeral. But I have got his letter copies for each member of the committee. Thank you.
Thank you, and please tell Mr. Harper thanks for sending that from McIntosh County. Do we have the mayor of Brunswick, Cosby Johnson, here? Welcome, Mr. Mayor. Thank you for coming. All right. All right. Ms. Hesselmeyer.
Thank you, Chairman, committee members. My name is Jo Hazelmeyer, but I do go by JoJo. I am here today as the VP of Business Development for DECRA. DECRA is one of the world's leading safety solutions provider. We were established in 1925, so a long-running company. DECRA performs millions of inspections annually, so we definitely know the inspection world. Prior to beginning my role at DECRA, I spent 32 years in public service with the Texas Department of Public Safety, including the role of Director of the Texas Vehicle Inspection Program. I was also the Texas State Inspection Association Deputy Executive Director, and am currently the chair of the Texas Vehicle Inspection Advisory Committee. I appreciate the opportunity to speak with you today as a subject matter expert and as a longtime advocate for vehicle safety inspection programs because I truly believe safety inspections save lives. My role today is to simply provide you with data and perspective on how vehicle inspections not only save lives, but could help benefit consumers and businesses in Georgia with respect to auto insurance. I am providing testimony to you today to highlight some of the items that I feel are critical for you to make informed decisions And while I would love to sit here and tell you about the perfect solution for high insurance rates would be to have mandatory vehicle safety inspections, I realize there are many factors that contribute to insurance costs, and asking for a mandatory vehicle safety inspection program is challenging at best. However, what I am suggesting is that you have an opportunity to offer a discount for those individuals who proactively seek a vehicle safety inspection. Anyone who has shopped for auto insurance is familiar with the plethora of discounts, everything from multi-policy, marital status, credit scores, certain technologies such as alarm systems or lane assist, student discount for good grades, as well as others. All of these are beneficial, but why not give a discount to those who ensure their vehicle is safe? It is mind-boggling to me that I can get a discount for being married, but I can't get a discount for making sure that my car has working brakes, lights, and tires that are not bald. Vehicle safety inspections are wins for everyone. Consumers win because the roadways are made safer, and financially, they could pay less on insurance. Insurance companies win because giving a financial incentive for a vehicle safety inspection could lead to fewer claims, reduce fraud, and overall save money. In the day and age when medical health providers, especially in rural areas, struggle with providing service, anything that can reduce the potential for any injuries would help to alleviate the burden on healthcare, which is a win. To support that vehicle safety inspections can gain the wins I just described, I want to point you to 3 studies. Also, if I've learned anything in my many years of working as a state regulator in Texas, it is that the legislature wants solid data and metrics. One of the known challenges for auto insurance is high medical cost. While a vehicle inspection doesn't control the cost of medical treatment, it can help reduce the severity of crashes that result in a need for medical treatment. A study published by CETA, which is a worldwide association of authorities and authorized companies active in the field of vehicle compliance, in 2022 suggested that states with an inspection and maintenance program, known as an IM program, had 5.5% fewer roadway fatalities per 100,000 registered passenger vehicles. This is further supported by the UT study as well. The Texas legislature mandated a study which was conducted by the University of Texas Center for Transportation and published in 2018. Crash rates and severity also contribute to high cost. I have included these studies as exhibits in my written testimony, but have taken an excerpt from this one to validate this statement. The average crash cost related to vehicles with defects are more than $2 billion per year. Most defects are vehicle elements that would have failed a program inspection. The frequency of fatalities, incapacitating injuries, and non-incapacitating injuries is higher for crashes involving vehicles with defects. The ratio of fatalities per number of vehicles in crashes is about 3 times higher for vehicles with defects than that of vehicles without defects. Crashes involving vehicles with defects are twice as likely to result in a fatality than crashes with vehicles that do not have defects. The most prevalent type of defect related to fatal crashes is slick or defective tires. Interestingly, 23.5% of survey respondents identified slick or defective tires as a vehicle element they had been asked to remedy during their vehicle inspection history, meaning that the fatality crash rate would likely be higher without such inspections. When vehicles from other states are involved in crashes in Texas, the percentage of vehicles with defects is found to be lower for those states that have vehicle safety inspection requirements than states that do not. This indicates that the inspection program in general may help reduce the number of defective vehicles on the nation's road. Ensuring that the vehicle owner remedies the defects found by law enforcement officers during roadside traffic stops can enhance highway safety. Vehicles with defects that were involved in crashes are 3 years older than the average registered vehicle, which is 9 years old. In other words, the percentage of vehicles with 1 or more defects that had crashes is higher for older vehicles. This highlights the importance of the inspection program to make sure that key components like tires, brakes, lighting of older vehicles are in good condition. Some other benefits are higher costs for repairs due to technology. So inspections that allow for preventative maintenance by identifying problems which can be addressed sooner. Early detection allows the owner to have the issue resolved quickly at a lower cost, like the medical world, where early detection can lower the cost. Another benefit is too many uninsured drivers. If insurance was mandatory at the time of an in-person inspection, then this could help reduce the number of uninsured motorists. Also, common sense would dictate that if insurance were more affordable, then more people would not have to choose between auto insurance and other daily living expenses. And the last benefit I'll speak about is insurance fraud. So in September 2024, Value Penguin published statistics about insurance fraud. In the report, they cite a study by Verisk in 2017 that insurance companies lost $29 billion per year due to insurance fraud. Vehicle inspections conducted in person by qualified expert inspectors would help to reduce the opportunity for fraudulent claims. Some examples of auto insurance fraud include incorrect odometer readings or claims for repairs of items that were not damaged in a crash, but were in fact due to daily wear. It is a complex issue, but I would submit that there are opportunities for improvement through vehicle safety inspections. Some of the major insurance companies do require some form of an inspection prior to issuing a policy, but generally it is not periodic and not necessarily by an expert that can truly evaluate the vehicle to ensure it is roadworthy and safe to operate. Most allow self-reporting and do not look at safety components such as tires, brakes, working lights, etc. The studies referenced focus rely on the safety aspect, but you can also draw a correlation for the effect a vehicle safety inspection has for insurance. Out of respect for your time, I've referenced 2 publications, but there are some others, such as a study by Carnegie Mellon University in 2015 and various recent articles on the topic of auto insurance fraud. Including an auto insurance discount option for a vehicle safety inspection is a common sense approach and a step in the right direction for public safety and consumer financial benefit. Thanks for your time.
Thanks, Ms. Hesselmeyer, and look forward to getting some follow-up from you on the inspection, potential legislation with you and Mr. Dunn, and also insurance fraud. Since you know about that also, please give us some examples from other states who were effective on insurance fraud. The insurance commissioner mentioned that's something we need to step up in Georgia to stop the fraud. So I appreciate you coming in and shedding light on this. Any questions? All right, Floor Leader Hong.
Thank you. Thank you for your presentation. How much does a safety inspection cost?
Are you talking about cost to the consumer?
Correct.
So in Texas, it was $14.50. So the state kept 7, and the station that performed the inspection kept $7.50. So it was $14.50 to the consumer.
$14.50?
Yes. Correct.
And you had mentioned that some insurance companies require these inspections before they, did I hear that wrong?
Yeah, not necessarily these types of inspections, but some type of inspection. I know, like for my insurance company, I just send them just a photo with my phone of my odometer. So various type of an inspection, but not necessarily. What I was trying to convey is not really the type of inspection I'm referring to, where you bring the car in and we look at the tires and measure the tread depth, and we check the brakes and see if they're functioning properly and look at the lighting. Most insurance companies are not looking at those types of elements if they do anything at all.
And I'm sorry, my last question. Are there any states that have it where they're giving discounts for these inspections?
Not that I know of. Okay. Not that I'm aware of.
All right. Thank you so much.
You are so welcome.
Thank you for coming to Georgia.
Thank you.
All right. All right, Mr. David Pattison, got a local insurance businessman. The speaker, when he got this committee started, he said, get out in the state, go listen to people, let the data drive the policy, and call David Pattison. So great to have you here.
So thank you, guys. My name is David Pattison. I'm the president of Sterling Seacrest Pritchard. We are based primarily out of Atlanta, but have offices in Columbus, Savannah, Tampa, Little Rock, and Birmingham. And we're an insurance agent, so we're not an insurance carrier. We don't set rates. We represent the clients, so if you come in and you're trying to get homeowners insurance or auto insurance or whatever, you would talk to one of our agents. We would shop it to various different markets, and so we would try to help you place your carrier, your insurance with somewhere. That's very different than State Farm or Allstate, which are what are called direct writers. So when you are working with them, they are the agent and the insurance company. So we don't take any, we don't have any insurance. We just represent the customers. So what I'm here today to talk to you about is the insurance marketplace in Georgia. And what I mean by that is, what do our customers who are shopping for either business insurance, personal insurance, or their homeowners, what are they experiencing trying to get that insurance placed in this day and age? And you saw a lot of data about, the claims and the cost and things like that. But most important, as legislators, what you want to worry about is the supply and demand of insurance. So if I'm trying to buy something, how many options do I have? And if I only have one, I don't have any control over what the price is. I just have to take whatever that one carrier is doing. So Georgia, I've been here for 40 years in insurance, and we have had the great distinction of, for many of those 40 years, being a very competitive marketplace. So, and things make a competitive marketplace. One, the storm are a part of it. Two is the vehicle traffic. Three is the things like natural disasters, things like that, and also the legal environment, right? So what has happened here is we do have tough environment because of the storms and things like that. And you saw that in the personal lines, but what I experienced, that's just kind of natural disasters. And the state legislature can't really do anything about that. That's just claims and storms and premiums. But what the state legislature can control is the environment that it makes it easier or harder for people to buy insurance. So when you have insurance carriers, they're filing rates and they're doing things, but they're also making a bet on the future of our state and the environment that they're trying to do business. And so if they don't feel as though it's a competitive marketplace, or they can't earn a reasonable return for their shareholders, they'll just move to another state. So for the first time ever in probably 2022, and we deal in all 50 states, it was the first time ever that as an insurance agent, if I told the insurance carrier that I was dealing with, and they might be in Detroit, they're not, they might be in New York, they might be in California, that my insured, the customer, the paying customer, lived or practiced in Georgia. It was the first time ever that they said, no, we're not interested. It's not a good state for us. And I think that's the thing. We can talk about tort reform, we can talk about claims and storms and things like that, but the most important thing from our legislature is we need to have a fair and balanced marketplace where people feel as though they can come and deploy capital here, because they have a choice at 50 other states. And you saw that if we're the ones that are at the wrong end of that field, then they're just not coming here. And the way to lower insurance premiums, so we can talk about rates all day, but the most important thing for the consumer is what their premium is. And the premium is a function of what their next best option is. So if I'm with the Travelers Insurance Company and my premium goes from $1,200 to $1,400 because of whatever, the house costs more, the rates are higher, whatever, like I don't have any option as a customer unless there's a competitive alternative. And the only way we're, as a state of Georgia, going to get a competitive alternative is to make sure that the rules and the regulations that are promulgated by our senators and House and governor are fair to all concerned. And that's the important part. If there's ever an imbalance, the marketplace will tell you. And Georgia, in my 40 years, has always had a fair and balanced marketplace, and people wanted to deploy capital here. They wanted to write coverage. They wanted to provide competitive alternatives. And for the last 5 years, I've had to tell my clients, I'm sorry, you're lucky that the people that you have right now will renew your coverage, because we don't have anybody else who's willing to take a bet on Georgia. And as citizens and legislators, that's almost like, I'm almost embarrassed that we can't keep our house in order enough to be a fair and balanced place to do business. So I'm here to answer questions, because I can tell you from a consumer standpoint what they're experiencing. I can also tell you from the insurance carrier standpoint kind of where their heads are and why they are not really excited about doing business here. So I thought it was just important for someone to talk about the marketplace versus rates and competitive alternatives, and how the consumer is actually physically impacted, and not just a small auto policy. Like, the thing that our state has to be most concerned about is the businesses that work here. I've got plumbing contractors, electrical contractors, they're paying $4,000 a year for auto insurance and per car. And that was $2,000 a couple years ago. And I'm sure Dr. Hartwig could tell us all the things that go into that, but even at double the premium, I don't have anybody coming in saying, hey, I'd love to write a plumbing contractor's truck for $4,000. They just don't want anything to do with it. So with that, Mr. Reeves, I'll yield to questions.
Thank you. Any questions for Mr. Patterson? Representative Williams.
Thank you, Mr. Patterson. Many years ago, when Moses and I were in the insurance business, there's always been difficulty with certain lines. I live in a timber heavy area.
Yep.
You never could get good deals for pulpwood trucks. And there were a lot, but this is nothing new. It's always been difficult, certain lines, to be insured. Now, I didn't like it then, don't like it now, because I wanted to sell insurance. But what has changed?
So in those days, because I dealt with a lot of logging companies and we had pulpwood trucks on the road, you know, there were a lot of laws about what pulpwood trucks had to do versus what regular trucks had to do. And it wasn't as much. So talking about the inspections and things like that, the legislation and the requirements on pulpwood trucks were lower. And so there was a higher level of failure related to brakes and safety and things like that. And I think that's what kind of caused a lot of trouble there. But now it's not really just a segment of the market. So it's not just the pulpwooders are having trouble or just the tractor trailers, it's everybody. So it doesn't matter if you've got a F-150 or a F-550 or a dump truck or a cement truck or whatever, it is universally difficult to get any kind of liability or umbrella in the state of Georgia because of the lack of availability.
Thank you, Mr. Patterson. Chairman Gullett.
Are there any states who are attracting a great marketplace right now? I know, I mean, inflation's happening everywhere. Parts of, replacing parts of cars is happening everywhere.
Yeah.
As far as the increased costs, labor costs increase is happening everywhere. So, what state is doing this well?
So I think
and why?
In Dr. Hartwig's presentation, you saw, if you looked at kind of the general averages of the premium to loss ratio, that's what the carriers are looking at. And they're going to go to a place where, there are less storms, there are better highways, there's less traffic congestion, the legal environment is different. I mean, it just depends. Like that's what they're looking for. So the insurance transaction's tricky because it's a spot market purchase for a futures market obligation. So I'm having to price something today that might not pay out for a year or two or three. So if there's inflation, there's an interesting statistic. 1 point of inflation requires me to increase my rates by 6 to 7% just to cover 1% of inflation for the future, just because of the cost of things going up. So that's the tricky part is we have to, everybody's got issues related to, to clustering of homes in tough areas, whether it's tornado exposure, whether it's river flooding. We're interesting because we've got essentially two coasts. We don't have a coast on the south end of things, but we're very susceptible to storms coming up through the Gulf, and that's been kind of the strange thing. People used to worry about everything coming in from the Atlantic. Everything that's happened to us bad in recent history has come out of the Gulf. So I think the carriers are having to look at the exposure to Georgia differently now. But there are plenty of places, Tennessee, Alabama. Alabama used to be the bad. I mean, they were like, when we were Georgia, we were like, well, at least we're not Alabama, Louisiana, or South Carolina. They were always worse places to do business than here. Now we're worse than they are.
So what about, so we did just have tort reform. Have you seen, and that was effective on the governor's signature, so that's been to effect for
Yeah, so
6 months or
as I
so?
talked about, the insurance transaction takes a long time to play out. So the claims that will be affected by tort reform largely haven't even happened or been reported yet. So for an example, an auto insurance liability claim, there's a 2-year statute of limitations, and a lot of time it won't even be reported until the end of the 2-year statute. And then it'll be litigated over the next 2 to 3 years. So as an insurance company, I don't know how the tort reform has affected me until that claim plays out, which could be 3 to 4 years. Now, what I will tell you, and this is what I told the speaker, for the first time in 5 years, because we did tort reform, carriers are willing to take a bigger, longer-term bet on the future of Georgia versus the past of Georgia. So I think that's the important thing for the legislature to know, that there are people coming in saying, okay, Georgia is one of the model states in the country that's dealing with, and tort reform is a tricky word. Legal system reform is, I think, more important for people to understand. And there's, and I'm certainly not here to tell you that my customers should be deprived of their ability to be fully compensated for their claims. But at the same time, we get measured against other states, and our court systems and the trial verdicts get measured very, very closely. And we have become a very difficult place for carriers to predict what the future looks like.
Thank you.
Thank you, Mr. Patterson. Definitely, as a independent insurance broker, and I see John Barber here also, definitely the door is open over the next few meetings. If you see some good models from other states that we ought to consider here in Georgia, definitely send it to us. Also, back in Metro Atlanta, December 18th, we have a meeting in Gwinnett County. I know you've got some good Georgia Bulldogs at your firm. Send them to testify and bring some ideas, and also to bring UGA's insurance and risk management to that meeting. We've heard from Georgia State, South Carolina. I know UGA's got a lot of insurance knowledge there.
Best thing we have in the firm. So those athletes, they're old and they're tired and they're gray. They can't throw a football. We have UGA. So Charles Seiler works in our office, so it would be much better for him to testify. I think people like to hear from him better.
Let's see. David Buhaker.
Good afternoon, ladies and gentlemen. Thank you for having me here to testify in front of the committee. My name is David Buhaker. I'm an attorney from Atlanta, and my practice revolves around what we call first-party insurance. In other words, I represent insurance policyholders when they have a loss and they're trying to help navigate the system, or they need help navigating the system. I represent all sorts of policyholders. I represent individuals, homeowners. I represent commercial claims, institutions, churches. It just runs the gamut. If you have insurance policies, you need help with them, that's the kind of work that I do. We're here talking today about insurance, but also we've been talking some about storms, Hurricane Helene. Today is September 19th, Friday, September 19th, 2025. Next week will mark a year since the storm, and a lot of people don't know, a lot of insureds don't know that next week on Friday, their legal rights run out. Sometimes your insurance policy has a provision in it called a suit limitations provision. It's similar to a statute of limitations, which people are familiar with. But a suit limitations provision is a creature of the contract, and it can be as short as 1 year after the date of loss. So the professor was showing us some statistics about the number of claims that were out there from Hurricane Helene, some of the number of claims that are still outstanding. Some of those folks might lose next week their right to legal redress, and they don't even know about it because it's contained in that policy. And it can be as short as 1 year from the date of the loss. Okay, so that's not just 1 year from the date the claim was denied. That's 1 year from the date of the storm. So you could be going on 6, 7 months after the storm, still trying to negotiate with your carrier. You don't even know that you've got a claim that could be potentially maturing until maybe 9, 10 months later. And then you're looking at a 1 year date of loss coming up on you, and you got to figure out quick what to do about your legal rights. So that's part of what I'm here to talk about today, is the perspective from a policyholder on the ground as far as what he or she is dealing with, because insurance, especially from a claimant's perspective, is very complicated. There are other lawyers in this room that have had claims. I'm sure there are people on this panel that have had claims before and have been just completely befuddled by the whole process because it's its own language, it's its own system, and a lot of times it's set up to be confusing. It's set up to be longer perhaps than it should be. I'll give you an example. I have a number of clients that I was actually discussing with my paralegal on the way down here today that I'm planning on filing lawsuits for here in the next couple of days. One of my clients had a tree fall on his house, and we saw a couple pictures from the professor about a tree hitting the roof. This tree destroyed my client's roof, and it separated it from the walls of his building. And if we remember Hurricane Helene, this happened in the middle of the night, and there was a giant storm, wind, rain, so the tree hits. His entire family has to flee next door, and he's got a giant gaping hole in his roof that the water's coming in through for the next day or so. He has still not had a final claims decision made on his claim, and next week marks a year. And he hired me, I believe, back in February of this year, and I have been negotiating and trying to help him through the Byzantine process of trying to get his claims adjusted. In that time, I've helped him. We have submitted hundreds of pages of documents at the insurance company's request. Anything having to do from receipts and invoices for what he spent during the storm to repair receipts and estimates, I should say, from contractors to get the work done, to receipts to show where he was living and what he was paying while he was out of his house, to credit card statements, hundreds of pages of this stuff that we submitted at the request of the insurance company before we went in to undergo what's called an examination under oath. And if you don't know, your insurance policy has provisions in it. It has duties that it imposes on the insured. One of those duties is to basically cooperate with the insurance company, which sounds innocuous, but that gives the carrier the opportunity to request a whole slew of documents about anything: tax returns, old expenses, receipts, estimates, invoices, photographs, videos, anything that they feel is necessary to adjust the claim. But also what happens is it drags out the timeline for adjustment. So I worked with my client for months to get these documents produced, additional months to sit down and go attend this examination under oath because we had to provide the documents in advance. And for those of you that may not be familiar, an examination under oath is like a deposition, okay? But it's not, there's not a court proceeding. I submitted hundreds of pages of documents on behalf of this client. We sat down for this examination under oath that lasted all day back in June, and we're still waiting on a claims decision. So I think that's reflective. We've heard a lot about rates and things, this catastrophes affecting everybody. I think we need to look also, as well as the more human element of this. What about the people that are affected by these storms? What's going on with them? What's happening as far as the delay, the interminable request for documents, for additional information, no decision being made, going on and on, all the while that 1 year limit is creeping up on him. And if he didn't have me, he wouldn't know about it. Most people don't know about it. You don't get a warning about it from your insurance carrier because you're presumed Everybody in here is presumed to have read your policy. You got that? That 60-page policy that you got, that you bought for your insurance, you're presumed to have read and known everything about it. So I wanted to come before the committee today to talk about some of the things that I see and that I hear from the people on the ground that are affected, that call me when they're at their wits' end and they don't know what else to do.
Mr. Buhacker, let's take a break real quick.
Yes, sure.
We are honored to have Speaker of the Georgia House, John Burns, here. Let's welcome Speaker of the House. Mr. Speaker, the floor is yours. No, well, we want to hear from you.
Sure.
Am I good right here, Mr. Chairman? Mr. Chairman? A lot of chairmen right here. Hey, Al. Glad to see you from Liberty County up here. So, welcome to all of our colleagues from Emory. What'd you do?
I did not get Elaine a cup of coffee when she asked.
No, well, good for you. I'm sure you've learned your lesson. It's good to be with y'all. It's good having all the friends from around this room in Southeast Georgia. It's part of God's country, Sue. I'll just tell you that now. So y'all seen a lot going on down here in this great hospitality in Savannah. House District 159 is about an hour up the roads where I live. So we're always glad to come to Savannah and be a part of everything here, and certainly a great place to have a meeting. Hope y'all enjoy yourselves here while you're here, as well as our guests and all those participating. So I'm excited about the information y'all are gathering for through this process, and it's one of those things we do that with our study committees, especially special study committees that bring information together that we can take action on if action is required. Certainly, we had a robust session, as we all know, in this year, 2025, and one of the big issues we took up certainly was tort reform, and certainly bring some balance back to that issue. But also, we as we complete that, we also know that we would like to bring some balance back and take a deep dive, if you will, leave no stone unturned, as into the insurance industry, ensuring the transparency for our customers, our ratepayers, hardworking Georgians there, working with it. I thought I saw the commissioner over there. I know he's testified before y'all previously, and we've got some ideas that he would bring forward that may be beneficial for him to accomplish his work as insurance commissioner. So we appreciate Commissioner King and what he's been doing and what he looks to do. So certainly those are ideas that I'm sure that this committee will take a hard look at and see if there's anything that may require action from the House. I'm sure y'all have had a robust session today and hearing great information and some great suggestions. I already got one of them when I walked in the door out there. So there's some good ideas out there. And I think that's what we do in the House. I know that's what we do. We gather the facts, and then if action is required, then we take action. But we take action when it's certainly we have the all of the information from every side of an issue to do just that. So, Mr. Chairman, I know you've been doing that. I know that's what you do for a living, and we appreciate your how many times have y'all met?
Mr. Speaker, this is our second, and we've got 3 more.
Second time. I thought this was your second. So I appreciate what y'all are doing. I know something about your first hearing. So we're looking forward for y'all to continue doing what you're doing, asking probing questions of folks that are presenting and folks in the audience that we can do just what we do. And that's always bring forward good legislative fixes if necessary to take care of Georgians, because we all know that we all pay premiums, whether it's quarterly, semi-annually, annually. That's part of whom we are to protect our property. And so we will look forward to continue to work with the insurance industry to see if there's anything we can do to assist that industry that will reduce premiums on Georgians and still provide the best care level of support and protection for all of our folks in this state. So I know that's what y'all are doing. That's what we expect you to do. And I feel very, very certain when I look around this room and look at the list who's serving on this committee, that you're going to do your jobs and you're going to do just that. So I'm very appreciative of that. If I may say one thing, a little bit divert briefly, because I know you have a schedule. So we're very proud of the progress in Southeast Georgia, especially, and y'all seen some of it as you drove down or you flew down. You saw some of that progress, and along with those that great progress comes great challenges. But so we have another issue now. We have some closures down here. Al and I have been talking about it along with great challenges will become great opportunity. So I want to just say to all of our colleagues, Al, in the House that understand the issues in the timber industry and the pulp and paper industry and those closures that have impacted about 1,100 direct jobs in Savannah and Riceboro in that industry that we're going to, and about 5,000 jobs, 4,000 to 5,000 jobs, indirect jobs in this area that support that industry. We're going to bring solutions to the table, and we'll bring those to you all. There'll be short-term solutions and long-term solutions that can impact that industry and protect the livelihoods of so many Georgians that are impacted in the timber industry. And so there's also a component, as many of these folks know, with insurance in that industry as well, that has a major impact on the cost of working and the cost of production in that industry. So those are all sorts of things we can look at, and I hope y'all will do just that with a focus on a lot of little things that are important to all Georgians. Thank you for letting me be here. I'm gonna hang out for a little while if that's okay, Mr. Chairman.
Absolutely.
I'll see if
Mr.
I can get a
Speaker.
per diem. I'm not sure if I can.
Thank you. We got the sign-up sheet right here.
Oh.
I know Representative Williams wants to say something. Let me just say, thank you for blessing us with your presence. We know you had a lot going on in Effingham County and then Statesboro, and it means a lot for you to come here. And also this panel, we got 50 states. It's a national problem. I don't know of another state that has a speaker who's put a committee with the task of looking at this for 5 hearings leading up to session. Thank you for the leadership. People of Georgia want some results in this area, and you put your finger on something that we're hearing a lot about from our constituents. So thanks for your leadership.
You've got some great members on this committee.
One of them's itching to talk to you. So
Yes, sir.
Representative Williams.
Thank you, Mr. Speaker. Certainly, we want to thank you for your leadership. After 1,100 people directly lost their jobs and another 4,000 or 5,000 adversely affected. While a lot of folk are doing a lot of talking, you're trying to plan to find a way forward. It's very important to my constituency and those certainly affected in the Savannah area. And we appreciate you, and we appreciate the continued effort, and we'll continue to talk.
That ripple effect extends all the way down the coast and very far inland. So we're gonna do our jobs, and we're gonna look for solutions that in the short term and the long term that helps these folks, helps our neighbors out. So thanks. I appreciate working with you and certainly all of the folks, and some folks in this room we're working with on that same issue. So thanks to all of them as well too. Thanks, Mr. Chairman.
And Mr. Speaker, Representative Williams said that he spent some time with Moses a while back. And if you got one of those picture Bibles, Moses is the one with the long beard. He's the snappy dresser.
All right, you must have seen the picture.
All right, Mr. Buhacker.
Thank you. I appreciate it. The only point that I wanted to drive home about my client that I was still talking about, which I think is typical of a lot of people's experiences after the storm. Like I said, it's rolling on a year. He doesn't have a final claims decision. Recently, he was forced to sell his house. He had to sell it at a major loss, and he couldn't do any of the work that was necessary to be done, so he had to sell it to a speculator. And this was a house that he lived in with his parents, his sister, and his grandparents, and he was the primary person that was taking care of all of them. So it's a real effect that happens and that I hear about unfortunately, all too frequently. So with that, I'll take any questions, anybody.
Thank you. It looks like we will have some questions. My question is, can you get us some templates from some other states that you think have some good models to follow? And then also particularly named storms, tropical storms, hurricanes, where you have a mass number of claims. Are there some good templates for us to consider in Georgia for some of the mass casualty situations?
Sure.
All right, let's see. Questions from the committee. Representative Kelly.
Thank you, Mr. Chairman. Mr. Buhacker, thank you for being with us. When we're talking about these periods of time where claims must be initiated or finalized, are we only talking about property damage with this?
Well, yes, we are in this instance, yes, because the period of time that I was talking about is in the contract itself, okay? If we're talking about a car wreck or a personal injury kind of thing, that's a statute, right? You have 2 years pursuant to statute. In Georgia, if it's not otherwise in the contract, you actually have 4 years to file suit if your property has been damaged. But the law is such that a carrier can reduce that 4-year time period all the way as short as to a year as long as it's in the contract. And so that's the time period I'm talking about. It's not a creature of statute. It's not a right that people have that comes from the law. It's strictly from the contract that they don't even know about until and unless they read it. And most people don't.
Are we seeing this in other states? I mean, is that something that our surrounding states, are they doing this implementing this policy in other states surrounding us as well?
There are some other states that have the 1-year limit, but there are others that have 2 and 3 year limits. I believe in Florida, they even have up to 3 years after the loss, for example. So other states treat you, if you change the statute, you could change the rule, because here's something interesting. This Hurricane Helene that we've been talking about was obviously a hurricane. If you have a fire, you actually have 2 years from the date of the fire to file your lawsuit, even if your policy says it's 1 year. And the reason for that is because the statute says, in the case of fire, you must have 2 years to file suit. That could be changed, but since it's not, since it doesn't apply to non-fire losses, it can be as short as a year.
The other states you talked about, Florida, that's 3 years. Is it statutorily set 3 years with a provision that says it's a matter of public policy that you can't shorten it contractually? Is that how they address that?
I believe it is, but I'm not a member of the Florida bar, but yes, I believe it is.
What about Alabama?
I don't know about Alabama. I can get you that information. What's that?
Thank you.
Yes.
Representative Williams.
Thank you, Mr. Chairman. Thank you for your testimony. And I wanted to emphasize to those on the committee to please read this handout that I passed out from Chris Harper. Chris is Senior Vice President of Southeastern Bank. And by the way, he was a big proponent of tort reform. But you need to read what his concerns are. And he has named some people and some of the problems he's having now that he'd never seen in 30 years of banking. You should read about Chris from Darien.
Chairman Gullett.
Thank you. Thank you for your testimony. Have you held, well, the very first meeting we had the insurance commissioner talk about a portal for complaints, consumer insurance complaints. Have you ever helped a client submit something to the portal?
I have helped numerous clients submit things to the insurance portal, yes.
Okay. Can you tell me about the process and what, in your experience, has happened when you submit something to the portal?
Sure. So the portal provides an opportunity for either a person, an individual, or their lawyer to go on to the portal and essentially make a complaint against an insurance company for a particular claim. Then I believe the process is that the carrier has approximately 15 business days to be able to respond to that complaint. My experience has usually been that when a complaint is filed, the carrier will bump the claim up, if you will, to a claims supervisor who then looks at the decision made by the adjuster and essentially rubber stamps it and sends a letter to the insurance, the Department of Insurance that says, carrier XYZ has said they've done nothing wrong and paid the claim entirely like they should have. We consider this matter closed. And then it's pretty much, we have to have a discussion with the client about, do you want to file suit or not at that point?
Have you ever had the claim, have you ever had things change? Have you ever been successful, I guess, making a complaint on the portal?
No.
Not one time?
Not in my experience.
Okay.
I mean, not with me, no.
Any other questions? All right, Mr. Buhacker, real quick, Bryce Rawson, raise your hand again. Bryce Rawson with Department of Insurance is here. In addition to the portal online, any other questions? All right, Mr. Buhacker.
Portal?
No.
Not one time?
Not in my experience.
Okay. The claim, have you ever had things change? Have you ever been successful, I guess, making a complaint on the portal?
No.
Not one time?
Not in my experience.
Okay.
I mean, not with me, no.
Any other questions? All right, Mr. Buhacker, real quick.
No.
Have you ever?
We consider this matter closed. The Department of Insurance that says carrier XYZ has said they've done nothing wrong and paid the claim entirely like they should have. We consider this matter closed. And then it's pretty much, we have to have a discussion with the client about, do you want to file suit or not at that point?
Have you ever had the claim, have you ever had things
pretty much, we have to have a discussion with the client about, do you want to file suit or not at that point?
Have you ever had the claim, have you ever?
And it's pretty much, we have to have a discussion with the client about, do you want to file suit or not at that point?
Have you ever had the claim, have you ever had?
Pretty much, we have to have a discussion with the client about, do you want to file suit or not at that point?
Have you ever had?
Our industry. I'm a new auto dealer on one side, but I'm also a collision center owner. So I own a collision and body shop in Statesboro, Georgia. And I just want to share with you a little bit of the concerns and how the process goes so that you're familiar with it, because I don't think that the majority of the public knows exactly kind of what goes on. But I am not the expert here. These guys here are the experts. They are all members of GCIA, which is the Georgia Collision Industry Association. They're all owner operators. Collectively, they have a experience of about 100 years together. Some of them are multi-generational collision center owners, and they bring a wealth of knowledge. So please ask them as many questions as you can. And I'm going to bring them up to talk in detail about it. But before I do that, I just want to give you kind of an overview of some of the areas. And this is not to point fingers or anything, but it's to bring light to an area. And I was really encouraged because the first three speakers that came up here really are arguing my case, basically, or our case. And you see the flyer that we put out here, there's 3 points in here, and they're going to go into detail with it. But the first three speakers gave a good foundation of a good starting
Real quick,
point.
Representative Franklin, is that the 2-pager with the QR code on page 2?
That's right. That's exactly right. So to give a brief summary, this is what happens when you have a wreck in your vehicle. You have a wreck, you make a claim, you go to a body shop or a collision center. They look at it, and every vehicle that comes in there has a standard practice that is presented by the manufacturer, whether it's a Toyota, Chevrolet, Buick, Ford, whatever. That manufacturer tells you or tells the collision center a list of things that need to be done to be able to repair that car safely and correctly, to be able to return it to its proper working order in that vehicle. So we write up the estimate, we put the repair together, we send it in to the insurance company, and it says, this car, the manufacturer is saying it needs A, B, C, and D done to it. When we do that, the majority of time, if not 100% of the time, the carrier will come back and say, I will do A and B. I may do half a C, but I'm not going to do D at all. And so that collision center operator has a choice then to either do exactly what the insurance carrier tells them to do, the A, B, and then return it to the customer, or to do all of it, eat the cost of it, and or try to get it back to the customer. So more times than not, we do the job complete and we do it right. My shop, for example, does it right. And if I have to eat it, I eat it. But we do it because it's a safety issue. And that's one of the points I want to harp on. It's a complete safety issue. If you don't do that, then the carrier is not going to be held liable. The body shop will be held liable if something like that, if they have a wreck or they have a situation in the future. And these vehicles are getting more and more technical. We have to there's sensors all over the bumpers, they're all like little spaceships now, basically. And you have to check all that stuff. A lot of these things aren't being cleared by the carriers. So one of my main points is that all that stuff needs to be done for a safety issue. The other point that I want to make is that, Georgians are paying a premium for this product. And they're not getting, a lot of times, they're not getting that product in full. A lot of times they're getting half the product because the corners are being cut. And there's a problem that we need to fix. So I want to let these guys talk about it, and they're going to go down this list and they're going to go in detail with it. But that's kind of the overview of what the situation is. Now, the solution to it, I don't know, because we got up here on the first slide and everybody's losing money and all this kind of stuff. And I'm not saying that. But what I'm saying is that we need to find a solution to be able to protect the Georgia consumer, and to also, if they're paying for that product, to give them the product, or don't charge the full amount for that product. So just real quickly, on point number 1 that I have up here, I forgot the lady's name that came up, but she was talking about the percentage of defects have run higher, and she was talking about the inspections, right? Well, that could be easily addressed by making sure that all of the cars that come into the collision center are done according to the manufacturer's policies, the A, B, C, and D, that they're completely done. That would eliminate a lot of issues, a lot of defects in the cars, because I guarantee you right now, that's not happening. A lot of those cars are getting repaired, halfway done, and those defects are going back on the road. The number two issue is the professor that came up. I forgot his name, the first guy that came up. But I was happy to hear him say that he said, with his knowledge, that he thinks a bumper, a repair to a vehicle, whatever, shouldn't take more than a couple of days. That's great to hear, because a lot of times in our industry, it's taken more than 20 days to get an assessment from a carrier to come out. What that does is it creates more cost in the rental bill. It's more delay for the consumer. They don't have a vehicle, for one. And a lot of times the carrier only pays 3 or 4 days for the rental, and we end up eating that cost, which is fine. We'll do that as long as it's safe. But there's no need to it if he thinks we can do it in 2 or 3 days. That could be an easy fix in the future. The last one, number 3, Mr. Patterson, I believe it was, he mentioned that he's an agent, right? He's not a carrier. I used to be an agent. I was an Allstate agent. I still have my license. So I have a great sympathy for the agents. And I want to work well with the carriers. But he mentioned that everything needs to be fair for all concerned. I couldn't agree more. Absolutely. And that addresses number 3 that we have down there. If we have universal standards across the board, you're not going to have the situation that we have now. One point in saying that, so when we fix a car and they say we'll do A and B, we'll ask them, why don't you do C and D? And they'll tell me, basically it's just because is the answer, but they'll say it is not the industry standard in your geographic area. That's the standard answer they'll say. But they will pay it in another geographic area, like Atlanta. They may pay A, B, C, and D because they're getting pushback from the collision centers, and they'll do it. Now, in Southwest Georgia, they may have 1 or 2 collision centers, and they may not push them back on those issues, and they will only pay A and B because they have programs set up, and you're a partner with the carrier. And they'll basically tell you that if you push back on that, we're going to drop you from this program. We're going to not make you a preferred collision center anymore. Now, steering is illegal in Georgia, and I'm not saying that they're steering, but they highly recommend for you to use their preferred collision centers. Okay? So you have small mom and pop shops in Southwest Georgia that are only getting paid for A and B, and you've got other places in Georgia that are getting paid for A, B, C, and D. Okay, I'll back off right now and let these groups say. Thank you.
Thank you, Representative Frank. Appreciate it. Committee, I appreciate it today. My name is Chuck Akers. I own and operate a collision center in Northeast Georgia. I do appreciate the opportunity to talk to this and the cost of our business, but I don't really want to focus on cost today. I think that's something else. I just want to talk about our business for a minute in terms of safety and what he just said. And I would say this, we're no longer a paint and body business. That's not our core focus anymore. Our core focus is safety, and that's to restore these safety systems back to their factory settings. Today's cars are not just machines with engines and wheels. They are rolling safety systems. The average vehicle on Georgia's roads today carries more than 30 advanced driver assist features, things like forward collision warning, automatic emergency braking, lane departure alerts, blind spot monitoring, and of course, rear vision cameras. All these systems are systems that we now take for granted. And when these systems are working, a 2025 MITRE study found that cars equipped with automatic emergency braking reduced rear end crashes by over 50% compared to those without it. Pedestrian braking systems alone cut crashing involving people on foot by nearly 10%. This changing technology saves lives, Georgia lives. But when these systems are damaged in a crash, they only continue saving lives if we repair them back to their original factory safe condition. And that is the responsibility that we carry as a repair industry. Repairing a car today is not simple, and it's no longer about hammering out dents and spraying paint. It's about restoring the technology that saves lives. The first thing that we do with a vehicle is not to remove parts or start making repairs. The first thing that we do is reference safety data to make sure that our technicians are safe from injury. while making the repair. Electrocution from high voltage EV batteries or faulty airbag systems can seriously injure or even kill our technicians. To do work safely, every shop must have the right tools, the right training, and the right environment. If any one of these pieces are missing, the tools, the training, the environment, or the safety checks out for our people. The repair may look fine on the outside, but it is not safe. And that's the risk that we must not allow for our Georgia families and workers. Last year, this legislation passed tort reform that allows seatbelt use or non-use to be admitted into court as evidence of negligence. That was a bold recognition that safety choices matter, and ignoring them has consequences. But I would ask you to consider this. What about a vehicle being repaired unsafely? Is a seatbelt anchor not restored to factory standards, or an airbag sensor not reconnected properly, or if a camera for automatic emergency braking is not calibrated, those systems may fail at the very moment that we need them most. That is negligence too. The tort reform bill shows that Georgia understands the importance of accountability for safety, and I would submit to you that proper collision repair is an essential part of that accountability. When we fail to repair correctly, we don't just make mistakes, we put lives at risk. We're blessed to live in an age of incredible safe vehicles. Seatbelts, airbags, crash zones, and now advanced driver assist systems are saving lives every single day in Georgia. But all of that safety only continues if repairs are done the right way. By restoring vehicles to their factory safe condition, that means proper tools, proper training, proper standards, and accountability for every repair. Because if we cut corners, families pay the price, not just in dollars, but in lives. Collision repair centers in Georgia are safety businesses. We are partners in protecting the public, and I urge you to keep safety front and center as you evaluate insurance cost and industry practices. There's nothing more valuable in this room than Georgia lives. Thank you.
You came from Northeast Georgia.
Yes, sir.
Where'd you come from up
I'm in
there?
Haversham County.
Haversham County. Okay, you're well represented by Victor Anderson, I believe. So,
Yes, sir.
all right. Thanks for coming.
Thank you.
Yes, sir.
Good afternoon. Thank you for the opportunity. My name is Jason Babb. I own a collision center in Chatsworth, Georgia. I'm here today to discuss a critical issue facing Georgia consumers. I'm going to be probably driving home some of the things that Lehman talked about, but the issue is a disconnect between vehicle manufacturers and the insurance companies. In the auto repair process, the issue is that it's leaving significant financial and safety burdens on our citizens. The problem stems from a fundamental conflict. Vehicle manufacturers, or OEMs, publish specific non-negotiable procedures for repairing their cars. These documents dictate what can be repaired, how parts must be replaced, and what calibrations are required for safety systems. These aren't suggestions, they are engineering mandates designed to restore a vehicle to its pre-accident condition and ensure its safety on our road. However, when a body shop submits this repair plan based on these OEM procedures to the insurance company, we are routinely met with denials from insurance companies. We hear phrases like, "We don't pay for that. That's not customary in your area. That's not competitive in your area. That's a cost of doing business, and you're the only one that asked for that." They refuse to cover the full cost of a safe and correct repair. This puts the auto repair shops in an impossible position and leaves us with three unacceptable options. The option number one, concede and absorb the cost, meaning we're not reimbursed for necessary repairs. Option number two, pass the cost to the customer, forcing them to pay unexpected expenses out of pocket for a repair they have already paid for through their insurance premium. Or number three, cut corners and perform an unsafe repair, which compromises the vehicle's structural integrity and functionality. All three outcomes are unacceptable. The customer who has paid their premium is not being made whole. Either they pay more out of pocket, or even worse, the roads are filled with unsafely repaired vehicles, putting every Georgian life at risk. We must prioritize consumer safety and fairness. Also, beyond safety, the process that we currently go through creates unnecessary and costly delays. A simple repair can be frustrating and can be a frustrating and protracted experience for the consumer. When a damaged vehicle arrives at our shop, we can't do anything till we get an initial estimate from the insurance company. Once we get that estimate, then we can disassemble the car and find all the damage that was missed on the initial estimate, create a repair plan, and then we must submit a supplement back to the insurance company. And then once the car is repaired, we're often submitting a final bill to them as well. So there's several areas where we wait on approvals from the insurance companies. These delays have a real financial impact. Most insurance policies only provide 30-day rental policy or rental car allowance. And we've seen many instances where a repair that should take only 1 to 2 weeks can be stretched to 6 or 8 weeks due to these approval processes. This leaves the consumer to pay for weeks of rental car expenses out of their own pocket, which is another unexpected and unfair cost. To be fair and do the right thing, we must hold all parties accountable. The consumer must be made whole, and our state should not tolerate a system that compromises safety and burdens our citizens with hidden costs and unreasonable delays. I do have a couple of real-world examples of the delays that I'm talking about. I have one car here